Item 28.
Yes, मतलब undefended suit मतलब उसके lordship ने 50 after preservation मतलब client has want to
You are appearing for?
plaintiff मतलब undefended suit.
Okay. Yes, item 28, please record an order. Learned advocate for the plaintiff prays for time as for to take necessary steps. Let this matter appear on 3/11/2025.
I'm grateful, lordship.
2018. Yes, call the list.
On the list. In this matter, my lord.
Yes, today is the date fixed for.
Joint special officer.
Yes, today is the date fixed for
And we are
report.
directed to file our report today only, sir. We are ready with the report. With your leave, we can file. I want to place something before your lordship. Report has to be filed pursuant to your lordship. Yes. Now, lordship.
What do you want to say? You want to take an exception to the report?
Clear violation of your lordship.
Okay. Take an exception to the report then.
No, what is there to take exception? He was only.
Everything is corrupted. Okay? So now, lordships, I made a submission before your lordship with the file written notes of argument that nothing had been reflected in the order sheet apart from me. At the time of argument on 22nd, my item live stream is stopped. Now we, pursuant to your lordship direction, I submitted my written grievances that has not been dealt with in spite of your lordship direction. Second submission of lordship, your lordship then, after taking over the charge, within 2 days a meeting to be called. Herein, my lord, the persons against whom a large number, my lord, the allegation has been brought against the particular person, he called for, my lord, a meeting. How is my lord clear violation? Lordship will not.
No, meeting was to be called by the special officers.
Yes.
So you have convened a meeting as per the order. You have reflected that in your report.
My lord, what I have reflected everything. My lord, again, as per your lordship's order. Let
the report be filed, exception be filed.
Call for the meeting, kindly see. They have been, kindly see, persons whom that, who is in.
Did they appear?
If I place my report, my lord, if you lost
Okay, please.
hand over.
So, my lord, we have lodged a complaint on 27.
Give the report.
Before the special officer.
What is being filed, my lord? I do not know. We have not been served. No.
There is the copy which has been served, the complaint which has been lodged before the special officer.
I am getting a copy right now.
That document, we have no allegation at present against my learned senior defense side. But I am hearing, my lord, before your lordship, the conduct of the special officer.
Huh?
Yes. Lordship, kindly see. Lordship,
Take exception. That is the right procedure.
no, my lord, he
Cannot make open submissions like this against officers of the court.
outside of the court.
Against officer of the court, you cannot take allegations like that. Take an exception.
You are also.
Take an exception. There is a decorum.
You are also part of the corruption.
Very well. Very well. You take exception.
So, senior
You dare not. You dare not say anything about me.
So senior is here.
Don't make personal allegations.
If you make the personal,
Do not make personal allegations.
Senior is there.
Maybe have a copy. You also. Please.
He has no capacity to argue this matter.
Keep quiet.
Kindly go. Come, argue this matter, then I will see how to done. There is the order.
Let me go through the report first.
We are also entitled to get the report because of that, pursuant to our complaint.
तो सही नहीं কি কোনো জিনিস নিয়ে এত যুদ্ধ করো তুমি সরে যাবে বুঝতে পারবে
Yes, copy of the report be circulated.
Lordship, may I make one suggestion? First of all, my lord, I was praying for the copy, my lord, which your lordship has already did. Second of all, my lord, may I say this? My learned friend handed over a copy of the notice. But your lordship will kindly say whether your lordship will entertain them, that they come and make all these submissions over here in court. But nobody comes when your lordship has directed the Shebaite meeting to be called. Nobody comes there. So it is only a fiasco meant for this court. Would your lordship entertain such a party? Your lordship, I've not seen the report as yet, but what I have been told is there are nearly about 100 people went there. And it is nobody's case that they have notice.
and they have notice of the meeting.
They have noticed they do not go because they know that in the Shebaite meeting they can't make anything because everybody else is will oppose them because they are happy with the system that is functional. They come and shout, scream, yell, make allegations, make personally insinuations against a lot of people. But in the meeting, nobody goes. So isn't this a violation, my lord, of your lordship's order? Would your lordship hear out a party who's violating your lordship's order? Your lordship said that the special officers to call a meeting of the Shebites. Once the Shebites are
They
meeting,
have assumed the charge, new committee.
yes, the new
Why?
trustees have
And they are
taken.
functional.
They have
Yes.
want uncontested.
No,
Yes, they want.
that
Yes,
is
they have
there,
assumed
but they have assumed the charge.
Assume the charge.
Assumed charge, accounts handed over, everything done. Next thing is comes first, the last portion your lordship wanted for the better management, that if at all any grievance is there, that should be redressed. Your lordship said, we bow down to your lordship's order. Absolutely. But if there is any, because all of us want that the temple to be run in the best possible manner. That was your lordship's intention. Your lordship said, let the special officer call a meeting of the Shebites. He will talk to the Shebites. If they have any grievance, he should thereafter call a meeting of the trustees and then have it inform them that so that necessary steps come. That was your spirit of your lordship's order. After that, does it lie in their mouth to say a word thereafter? Because today they get notice of the Shebaite meeting. They have come and they handed over to your lordship the copy of the notice. Thereafter, they don't attend. With greatest respect, anybody who's violating your lordship's order, they don't express any grievance in the Shebaite meeting. Would your lordship entertain them any further? My humble submission today is that.
The remedy is to take exception to the special officer's report. That is the.
What is there? I humbly ask myself, was the special officer meant to do anything, very heavy job, or he has done anything? Your lordship said, number one point that your lordship asked the special officers to do was handing over charge from the old committee to the new committee. As far as that is concerned, nobody else is involved. There was no grievance as far as that. Next, your lordship said accounts to be handed over from the old committee to the new committee. As far as that, nobody has any grievance. Number 3 is call a meeting of the Shebites. As far as that, they do not attend the Shebite meeting. So they cannot have a grievance on that. Number 4 is that any grievance of the Shebites, the special officer to communicate.
Honored advocate representing the trustees was present in the trustees meeting.
In the
That is your junior, that is your advocate.
in the first meeting, but Shebite meeting was not
No,
present.
no.
No.
Subsequent
Yes,
meeting with the
no,
trustees.
yes. So over there, then your lordship's view was that there is any grievance, that grievance the special officer should indicate so that the trustees can take remedial steps if at all there's a problem. Nobody present, nobody has any grievance in that meeting. Then, my lord, what is there for the special officer to say and what is there to take exception? My lord, today, having not attended the meeting or not having expressed any grievance, I do not think, my lord, I think that they have forfeited their opportunity to file an exception, my lord, with greatest of respect. My lord, your lordship gave them an opportunity which they did not take.
My lord, if I may also add, my lord, before even I started my work, these two Shibayats, my lord, they through their letter have sent me written grievances, which I have also placed before the committee, my lord. Trust. To make it transparent.
What is there for the statement?
Yeah, what do you say?
Now kindly lordship, kindly come to your lordship's order. On 23rd of July 2025, lordship specifically directed the learned special officers shall call a meeting. Persons against whom was a complaint before the special officer pursuant to lordship direction. When your lordship pass an order? 23rd. I lodge a complaint before the special officer 27th.
Could he? He could not have.
Yes, my lord, I have submitted kindly.
No, he could not have.
My lord, it's a lordship direction is
No,
there.
he is in the Shebite
But-
meeting.
No, that is not the according
Please.
to your explanation.
No, please.
My lord, kindly come.
Huh,
Learned special officer pursuant to taking over the charge by new trustee hold meeting with the present Shebite within 2 days.
yes.
Now, upon holding meeting with the present Shebite and considering their suggestion or grievances, if any made Shebite hold meeting with the board of trustees.
In the-
within two- I am coming, my lord. So
Did they go-
communicating the grievances to the Shebite for doing the needful so that the both estate can be better administered in accordance with the law. So far the first line is concerned, where is the notice issued by the special officer to call a Shebite meeting? Where is the notice? First submission, that is a clear violation of your lordship. The special officer has not acted in terms of your lordship. Second submission. So now the grievance persons against who called for, I have handed over the notice which has been issued. My lord, the person, no one shall be judged in his own case because of that meeting called for.
My.
A Lord, kindly come to next, my lord, that what is our grievance? Kindly see with the evidence that estate property has been sold out.
What stopped them from making these grievances in the Shebite meeting? I asked myself.
Lodge a complaint before the advance because of
Why?
my lord, this, where is the
Why were you scared to
Why?
attend the Shebite meeting?
Why
I'm asking
special
this.
officer has not acted in terms of your lordship's order? Why not? Why not, my lord? This is my first submission. If the special officer called a meeting, then we may not approach before the attend the meeting. Then it is the clear violation in the lordship's order. Kindly see that once again. I am reading my lord.
But you need to peruse the report before making any submissions.
Lordship.
Without report, please don't make any submission.
I would like to see the report. my lord. I'll
Yes.
tell you that.
Because- No, I won't permit any submission without producing.
Absolutely. I bow down.
Yes, record an order.
Record my submission.
Please.
My lord,
Please
my lord,
record an
record
order.
my submission.
Learned advocate for the trustees.
Record my submission. That them, my lord,
You are representing which Shebite?
No one.
No, which Shebite are you?
Easy representation.
lodge a complaint.
I'm granting
This
you.
is another Shebite.
The-
My lord, everything has.
Please.
I have already submitted. Have you placed it? I have already given one day. Kindly have a look. Your lordship pass any order considering.
Please. This is what your application.
That will be tested.
What is this? What is this GA 42?
That is to be.
No, no,
No.
what is this GA 42 now?
42 is my application. I do not know how we have written that.
No, no, what is,
Yes, because your lordship, kindly see my grievance, what is GA 42.
no, no, I have passed an order in GA 42.
It has been filed by one of the Sebais who has appeared before your lordship and argued this
So
matter.
you have argued this matter. After hearing you, I have passed the order.
Because of my submission is not recorded by your lordship.
Oh,
Last occasion also not recorded.
Yes.
In spite
Now-
of the submission,
now-
it is
now-
not what is going on. The division,
No, no.
we have already.
Let-
before the
Let me
division.
accept the
And
special
this is
officer's
our
report.
forum.
Learned advocate appearing.
Lordship not.
my lord, your lordship, pass your lordship's order. This shouting will not stop.
No, this is shouting is what is going on.
From Mr. Banerjee, Amitesh Banerjee, my lord, it is very.
The corruption is corruption everywhere.
At this age of 72, it is not expected I am here shouting, because I will not be able to compete
What-
with him.
What is he doing?
What is, because my scale of sound will not be.
Incompetent
But
special
what
officer
is
has
the-
been
My
appointed.
lord, one thing I am submitting, my lord, kindly stop recording.
While delegation,
Submission.
And my lord, his.
while delegation, they will
I am making my submission. Record my submission. This is not the
not to
master.
the special officers.
But I am
He
saying.
is not acted on terms of the High Court's order.
Fraudulent practice in association with the special officer or not. Exception to the special officer means that means I am accepting a special officer. If the special officer is doing the entire exercise on the basis of the fraud, then my lord, we are coming here. Therefore, my lord, kindly, my lord, restrain yourself for passing the order, at least given us some breathing time, my lord. My lord, kindly stop, my lord, kindly hear him, and thereafter here, my
No, no,
lord.
it is appearing as to be mentioned
my-
unless you go through
It
the,
has come to be mentioned.
they are challenging,
No, that is not your lordship
they
direction.
are challenging the special officer's report.
No, my lord,
No. If your lordship, the documents are administered by this High Court, lordship cannot shut the eyes that taking that lordship has given.
Today is fixed for special officer's report.
So now.
Now,
Kindly hear my
my lord,
submission
kindly
prima
hear-
facie.
my lord, kindly stop.
Prima facie, record my submission and pass a necessary order which I take appropriate step.
Stop, my lord, for a moment. At least let us have.
বসুন, বসুন, বসুন।
My lord, at least submission, my lord. Yeah.
My lord, my respectful submission, whatever I make my submission, last occasion I make my submission with the written notes of argument that has not been reflected in the order sheet. Lordship had taken note, the written notes of argument submitted by the Sebai, one of the Sebai, kept with the record. Now on 22nd, 27th, that has not been dealt with any
I have
paragraph.
passed an order,
That is the,
so I cannot vary that order.
we have already taken it. Now today I am making the submission when this Dakshineswar temple administered by this Honorable High Court. Lordship want better management of that temple, even my lord pending of the division bench, Lordship pass an order. We have taken steps. That will be taken care. Now Lordship's order. When your Lordship specifically directed the special officer to call a meeting and ventilate and to address the each and every allegation against the misappropriate of the fund and misappropriation of the state property. We lodge a complaint before the special officer before handing over the charge to the new trustee board. On 27th, we lodge a complaint with a concrete evidence. Whether pursuant to your lordship direction, any meeting has been called or not. That is the first submission before your lordship. Apparently, your lordship has gone through the report. Lordship sees special officer has not called for a meeting. Person against whom a lodge a complaint, he called for a meeting. So now lordship will not interfere at this juncture for better treatment or better administration of the Dakshineswar when it is the public temple. Lordship's temple, Lordship Lord knows the Ma Bhavataruni is there. We are not nothing to do. Ma Bhavataruni is there, my lord. So hearing my lord is kindly see it is a clear violation, it is a clear collusion with the my lord present trustee board and the special officer. I lodge a complaint. So now your lordship can, at the threshold, lordship can interfere, only that allegation. Now I am not going to that, going through the allegation, that is the part of the special officer. If the special officer will not call for, will not act in terms of your lordship's order, your lordship will not interfere. Prima facie, I am not going, I have not seen the any report. But if this document can show before your lordship, I have no case. I will not argue today. This is my respective submission. Prima facie, my lord, I am not going to my report, whatever I may be. They are the very gentleman admittedly, they have no corruption, may be wrong, my lord, this false allegation has been made. Where is the, my lord, the meeting called by the special officer? That is my respect to submission. Let them to, my lord, prima facie satisfy, record my submission. Now, your lordship, leave it to your lordship, pass this, my lord.
May I make one submission? Oh, let
No,
Mr.
no,
Odhikari. No, let me say. No.
Mr. Banerjee is eager enough, at least
Your-
yes, Mr.
রয়ে
Banerjee is
যাচ্ছ
enough.
রয়ে যাচ্ছ কেন?
May I submit?
রয়ে যাচ্ছ কেন?
He's representing
No, let Mr. Odhikari submit thereafter.
হ্যাঁ বিজয় বল।
Thank you, Lord.
My lord, that I am one of the, at least the oldest civils. And my lord, that out of 600, my lord, your lordship, rightly see, I am very near to, my lord, that the Dokhineshwar. Every day, I go and I watch, my lord, since last, my lord, that we dawn of, my lord, my practice, my lord, what I understand, my lord, in particular person,
No, are you a party in this application
my lord,
on GA 42?
my lord, Snehanshu, my lord.
No, GA 42.
Was I, and I have.
He was argued, he was participated. Mr. Abhijit Sarkar, my lord, your lordship, next day, my lord, our name has been recorded, GA 44, that has been taken, one of the Sebai. Lordship direction is
No,
very
I have passed order in GA 42. Okay.
42, we are the intervenor.
Okay. Whatever you have to submit, you submit with GA 42.
Yes, I am submitting.
GA 42. No. GA 42. Did you argue this matter? Probably you have argued GA 43.
No.
That order matter was considered by Justice Pattonai.
42 argue করেছে আগের দিন।
My lord, that the GA 42, it was the midst of argument. My lord, here was a case before Honorable Supreme Court, my lord. Before Honorable.
No, I am confining myself to GA 42.
Therefore, my lord,
But
that in GA.
Did you argue this GA 42 when the matter was taken up?
Yes, my lord. 42.
For whom did you argue?
Counsel, my lord, my client, my lord, that the. My lord, I argued before
2025 এর
Yes,
order
my
ছিল।
lord.
25 তারিখের
When
order।
we have a
No, you see,
25th order.
probably for the intervening Shebayet, I have heard the arguments, but you are arguing for whom?
Kindly see my. You not to kindly. I have come, my lord, and with this.
No, I am confining myself to GA 42. Did you appear in
Yeah, this is
GA 42 on the when the matter was finally heard out? You appeared for whom?
Yes, my lord.
Because you were not there at the time of argument.
No.
Yes, and because of the, I had been before Honorable Supreme Court and I have been
My
told, but I
junior,
could not.
my junior.
My junior was there, my lord.
Yes.
My lord, at that point of time.
So what your junior has submitted, you want to add something?
My lord, yes, my lord.
Yes.
You also tell me. I am, my lord, that is.
আপনি 42 এ আর্গুমেন্ট করেছিলেন কিনা
Yes,
সেটাই
yes,
বলছে
my lord, kindly see, my lord. My lord, that here it is, my lord, at page 2, I have stated, my lord, clearly. That I am one of the Sebaik out of about 600 Sebaik of Dokhineshwar Kalibari and Devottor elected and intervenor of the aforesaid application. This Honorable High Court has passed several orders in connection with the aforesaid administrative suit in CS number 308 of 1872.
You see, in GA 42, I have passed an order. So I cannot go beyond that order. If you are aggrieved by that order, you come with necessary application or go higher up.
My lord, very painful.
They've
but-
gone.
My lord, very painful on that day. My lord, that is when the matter was going on disturbed. Therefore, my lord, I have no personal grievance with anybody else. My lord, after covering my 5 years of practice. But my lord, when in presence of Mr. Banerjee, Honorable Justice Bivas Pattonai, my lord, that is immediately that matter I have
No,
heard
no.
and I will hear next time. My lord, unfortunately, my lord, the matter could not be heard and my lord, he has managed the order. Therefore, my lord.
What is the language being used?
Yes,
I have managed the order
yes.
from a
yes.
judge.
I have gone through the
I will write down it because knowing full well that on any occasion, my lord, that I had no other alternative, but in a final hearing, I am to go and my lord, I have informed, but my lord, that they have suppressed. And my lord, that on that day, my lord, that I had no occasion at least to return in Calcutta. My lord, I have tried. But my lord, from Delhi, it was not possible. My lord, he has taken it. Therefore, my lord, if my submission has been kindly have it, my lord, with full analysis, my lord, if that be the application, my lord, what I have stated there. Now, prior to 1986, what is my statement? Kindly have a look, my lord.
No, see, first, just try to understand. GA 42, I have considered the affidavit in opposition, okay? Upon considering the affidavit in opposition and the reply, and upon hearing the parties who are present, the trustees and the Shebayets, I have passed an order. So I cannot go beyond that order.
My lord, if
I cannot improve anything.
Actus curi neminem gravit.
Yes.
The court can rectify its own order at any point of time.
Yes.
If your lordship will kindly see, because we are crying for justice, we have not been given proper opportunity. Whether it is beyond your lordship's control, at least that is to rectify your lordship's order. My lord, if your lordship will give the very line of it, my lord, that is the core of my heart, my lord, I am the survived. My lord, that your lordship is possible the matter at the, my lord, that maybe by the loud sound of the other side. And my lord, that for me, it has been told, Mr. Vijay Adhikari, unfortunately, he has come to Delhi, and for that day it is such. And my lord, that my petition remains unattended.
So far, GA 42 is concerned, nobody made any prayer on your behalf.
My lord, my junior critic, my lord, that the
Nobody made any prayer on your behalf in GA 42. I have only heard GA 42. I don't know what prayer was made in other courts, but so far this court is concerned, no prayer was made on your behalf.
The moment I have got your lordship's order,
Yes.
my lord, it has like a means called in the blue. My lord, the moment I have got your lordship's order, my lord, it shocked me to such an extent that even if for your lordship's order, my lord, be taken up in consideration. Kindly have a look, my lord, that your lordship, my lord, whatever your lordship will do, your lordship has got ample power at least that it will go within the limit of your lordship's order. My lord, that there is no quarrel. I think my other side also, so far the settled principle of the law, he will not oppose. He will not make any opposition. My lord, this application, your lordship's order. The court, this application is moved by the duly elected trustees of the Dakshineshwar Kali Temple and Devotar Estate, praying for the following orders. Your lordship's order, my lord, that is the first. On 23rd July, your lordship passed order. Leave to file this application by the present trustees. My lord, leave to file this application, duly elected trustees. I am opposing one thing. Your lordship has recorded duly elected trustees. And my lord, when your lordship's lines start in this way, this application is moved. Your lordship's order at page 13 by before the Honorable Justice Vishnu Chaudhary, dated 23rd July 2025. Therefore, my lord, when your lordship's order is passed, it is not a narrow pedantic kibbled order. Your lordship has got some broad amplitude. That means that the duly elected trustees, my lord, since the my lord days of Honorable Justice Bobby Saraf, my lord, that even my lord, his lordship was that while I am living, but Mr. Adhikari, I have now come to understand that, well, there is something wrong. Therefore, my first question was, since the very day I was saying, that means they are raising that I am duly elected. I say that I am the senior advocate with no ground. It is not. Therefore, my lord, that they are, my lord, that is voluntarily saying that whatever I am doing is duly elected. My lord, is it duly elected? Therefore, your lordship, in supposition that there was a duly elected previous committee and they have filed it, therefore, your lordship has echoed it, lordship's order at the first line, duly elected. But whether it is duly or unduly, it has been on the hotbed of the judicial scrutiny. During the judicial scrutiny, my lord, thereafter, one after another was passed. Therefore, if the election process of the previous year, even the election officer's duty has been put under challenge, that means the election.
What is your? Are you adapting the submission of your learned junior that there was error committed by the special officer, or it is totally dehodes the law, or are you challenging my order?
I am saying that your lordship, that order has been passed based on the fraud, based on misrepresentation.
Very well.
They are doing it.
So I cannot set aside that order without application and without hearing the other side.
Yeah, that I am saying. Therefore, my lord, if my lord, that they procured one order, my lord, from this.
If an order is obtained,
Is procured.
Yes.
an order is so to see.
Yes.
What words are
Yes,
being used?
yes, because first line, my lord, the duly elected trustee, my lord, the
Procured.
impression was brought by Mr. Banerjee's group. My lord, that means that you were duly elected, your lordship passed order, that there will be entire exceptionality.
Okay. Very well. So question is, if an order is obtained by fraud,
Yes.
before the court will recall that order, the court will seek an application on affidavits and grant opportunity to the parties to contest the same. Okay.
Therefore, my lord, let opportunity be given first.
So you are representing whom in GA 42?
I am representing, my lord, that there I have already stated that Snehanshu Chaudhary.
Yes, you are representing whom?
I appear on behalf of Devjani Das.
Where? You
My
appeared probably.
opposition file is Vikramjit Das and Devjani Das. Both are my the Sebais of the temple. My respect, whatever my learned senior pen has submitted, I don't the adopt this submission. Apart from this, I have to na. I'm coaching. Apart from this, I am only. It is his matter. I am not adopting.
No, he represented one of the Shivaites on the last occasion.
He is also- one of the Shivaites.
Nobody sought time on behalf of Mr. Odhikari representing the Snehangshu Chaudhuri.
Yes.
Nobody sought time on his
Nobody.
behalf
In fact,
representing.
if Mr.
So you
Junior was
represented
there,
that Devjani Odhikari probably.
Ballot, may I?
That's
That
Shivai.
has to be clear before your lordship. My learned senior friend's client is also one of the Sebais. Last occasion, argued this matter, Mr.
No, he was not represented.
Malad represented. Obijit Sarkar.
No,
yes, but
Yes,
Mr.
but-
Thakur never took time.
No, not time.
Nobody sought time on his behalf.
No, he did not sought for time. He, in his absence, he
This the
argued this
matter.
matter. He argued.
Yes,
Next day,
when
when
argued the matter.
Yes, my lord. Today, my lord, I cannot reopen your lordship's order. Whatever the order has been passed by on 23rd of July, I don't like to reopen. That is not the due process of law. That has to be taken care before either paper an appeal or to file an application before your lordship for recall. I am not on that. I am only on that pursuant to a lordship's order whether the special officer acted in terms of the true spirit of your lordship's order or not. This is only submission. So if your lordship prima facie found that in spite of acknowledging or accepting our grievances as directed by your lordship to submit before the special officer, that has been acted upon by the learned special officer or not. That is only my point before your lordship.
Okay. What was the name of the party you appeared? Shivait?
Sebai Vikramjit Das.
No. You appeared for whom?
Vikramjit Das.
Vikramjit Das. On the last occasion.
Lordship opposition, my application, Vikramjit, my opposition has been considered by your lordships. That has been submitted.
Yes. Record and order.
May I make one submission? I'll just take 1 minute of your lordship. Lord, we are making allegations against very senior members of the bar who your lordship has appointed as special officers. But I condone this sort of attitude. If at all anybody has any grievance, he should put it on any in an application before your lordship. Nobody has done that.
Yes, that has been done. That has been filed today.
We have not been served as yet.
So now we have no allegation against Mr.
No, but I have to be served.
Yes, record and order.
Yes, it has been served.
Mr. Banerjee, learned advocate for the applicant trustees.
I have
Applicant
allegation.
trustees, please. Applicant trustees.
Yes.
And Mr. Odhikari representing the Shivait intervenor, Snehangshu Chaudhuri. And your name, please?
Pankaj Halla.
Mr. Pankaj Haldar representing the Shivait, Vikramjit Haldar are present.
Vikramjit Das.
Vikramjit Das are present. Learned Special Officer, Mr. Amitabh Pal and MS Shati Mukherjee, who are appointed as Joint Special Officers in terms of order dated 23rd July 2025, are also present. Today was fixed for filing report of the learned Joint Special Officers. Learned Joint Special Officers have filed the report. Let it be kept with the record.
Well, circulate.
Let the same be circulated also by the learned Special Officers.
Then copy
But I am here and now,
Yes.
but your lordship.
Yes.
And Mr. Odhikari?
Mr. Odhikari, one of the Sebai.
No, I'm just recording. Let the report be circulated, if not circulated in the meantime.
Yes.
But today I am serving.
Okay. Mr. Pal submits that the report is already circulated. Learned advocate
ওনাকে
appearing
দিবেন তো
for
উনি তো
the
কমপ্লেন করেছে আমরা
Shivait Vikramjit Das submits that the learned special officers have violated the court's order and have not held the meeting, and the meeting was held by a person against whom the allegation exists. Stop.
আমি না বললে আমি আপনাকে
Exists.
আমি মিথ্যা কথা কোনো দেখো
Mr. Odhikari, learned advocate representing the Shivait Snehanshu Chaudhary submits that the order dated 23rd July 2025 was obtained by misleading the court, and many facts were not brought before the court. Stop. Were not brought before the court. With regard to the submission of the learned advocate appearing for Vikram Das, that the learned joint special officers have not acted in terms of the order passed by this court, this submission cannot be accepted at this stage because the submission is made without perusing the said report. Thus, the same report may be perused, and if necessary applications can be made. With regard to the submission of Mr. Odhikari that the order has been obtained by misleading the court and by suppression of material facts, this court is of the view that once an order is passed upon hearing the learned advocates, this order cannot be modified or recalled without necessary application in this regard. Stop. Let this matter. Okay. So liberty is granted to the parties to take necessary steps.
No, so let the application be
Yes,
filed,
yes,
then it will be.
and
listed.
thereafter
I don't know anything.
thereafter
Get the
the
number.
matter may be mentioned.
Yes.
No, I have already filed it.
My lord,
My lord, I have already filed it today.
Mention it, mere filing will not do.
Yes,
Mention.
then I-
Mention that application will appear.
my
After such of the-
my lord,
After service.
my submission has not been recorded.
What submission?
My submission before your lordships, I have gone through the report. My specific submission before.
No, I have gone through the.
No. I gone through.
No, when you are making the submission, did you go through the?
No. Your lordship has not recorded.
Just now.
Pursuant to a lordship direction,
I have
no
recorded that.
meeting has been called for by the special officer. That is
Okay,
not
I
recorded.
have yes,
Kindly read, my lord.
I have recorded the special officer has violated. The
No,
court's
that
order.
is not called for. Because of that, we have already prepared an appeal. Appeal court will take care.
Special officer has violated the court's order and have not convened the meeting. We can best convene the meeting, but the meeting was convened by one person against whom allegation exists.
Yes.
With regard to the submission against the special officer, necessary application may be made for regarding taking exceptions. The matter may be mentioned after the necessary applications are filed. Learned joint special officers are entitled to a further remunerations of 300 GMs each.
No, they have also preferred an appeal.
Mala, this your
What's the
lordship has.
to get into this?
No,
all these issues?
not
Let the
necessary.
appeal court decide it.
Yes.
Take this point when they move the application.
No.
Because,
No.
okay, but
Madam,
if I can submit,
If they file an application, let it be
they
part of
filed an appeal.
the application regarding.
No, they filed an appeal before the appeal court.
So you
They are
take
not moving that.
no. You take this point when the application is moved. I shall
Then-
pass necessary order.
No. My lord, lordship.
In the meantime, please further remunerations.
Mala, this only some.
I am not discharging them at present.
Mala, till the disposal.
So then why put them to the humiliation as they are faced today? I feel humiliated myself. I know both of them.
They are taking the additional trouble. So please pay the additional remuneration.
Mala, may I want submission?
Yes, my lord.
That this matter will appear since your lordship liberty given and abide by result of the appeal. After disposal of appeal, I can.
Very well, I have granted you liberty to mention after
No,
necessary.
only
application.
one line, my lord. After my lord disposal of the appeal.
That is not necessary.
But the lordship has held this order will abide by the result of the appeal.
Yes.
Yes,
definitely.
lordship will. So now this matter will appear once again after disposal of the appeal till the disposal.
I have granted you to liberty to mention after necessary applications are
Application
filed.
filed, yes.
My lord, appeal. Lord, when your lordship order paper and
Let us. This will be never ending.
I am not praying for any order, further listing the matter. I am not praying. I pray before your lordship. So since this appeal is pending, this application will appear if the necessary application filed by.
See, it is up to you whether you want to get it heard before the appeal or not.
Don't
If you-
mention.
If you don't want the matter to be heard before the appeal, don't mention.
Yes, absolutely.
Yes, call the next.
Item number 2.
Unnecessary, we are creating.
You have already.
Item number 2.
Item number 2. But you will kindly see the last order of 21st of July.
I appear for the petitioner in this matter. This application is mine. Milord.
Please, I mentioned the matter before Lordship.
Let us see the order.
Yes, there are some difficulties that we are facing. Milord, I'll indicate. Order to Lordship ke do. Na, ota order debe. Now, Lordship, the first thing is, now Lordship will see the appearance. We appeared, Joydev Godai, Deeptesh Godai and the others set of advocates. They appeared, Lordship is recorded, for Fatima Khan and Hasim Yusuf Mamsa. That's recorded there, in the appearance part. Now, if we read the order, the learned advocate have represented the commissioner of partition and the advocate representing the applicant, and learned advocate representing Fatima Khan and Yusuf Ahmed Duple. This name has gone in wrongly.
Yes.
So this is,
So today it is happening only for rectification.
I'll just before rectification requirement. This Fatima Khan is correct. So the other name will be Hasim Yusuf Mamsa instead of Yusuf Ahmed Duple. This is the first.
No, but applicant.
No, he's
Now this is the
So-
first.
Fatima Khan is the defendant number?
Now I'll tell you, Ashil. Let us read the order once.
No, the applicant,
As-
Milord,
I mean,
is
I-
Masood Duple.
No, that's the applicant.
So my applicant's name is recorded in the second line,
No.
representing the applicant. So Mr. Alim assisting
Learned
me.
advocate representing the
Applicant
applicant
and
learned advocate representing your client is
Fatima
Fatima Khan.
and Yusuf. Whatever.
Fatima
Milord.
Khan and Yusuf Ahmed Duple.
Is
Yusuf
opposing.
Yusuf Ahmed Duple has died long back.
Okay, so your
In
clients are
1970, he has died.
okay. So your clients are Fatima Khan and
Hasim Yusuf Mamsa. The name is there in the appearance. Now she will see the appearance.
this person is a party now implicated. as a-
I'll tell you. Now she let us read the order then. Although it is not available from record as to whether Fatima Khan is a party to the instant suit, but Yusuf Ahmed Duple, this will be once again Yusuf Mamsa, is the defendant number 3 in the instant suit. Opposition to be filed. Now if you turn over to the page kindly. The learned advocate representing Fatima Khan shall justify on the next occasion as to whether on the basis of which order Miss Fatima Khan has been added as a party. Now I will tell you the cause title on which this petition is filed. Records Qasim Ahmed Duple, Muhammad Ahmed Duple. These gentlemen has died maybe 30 years back. So the entire petition is based on the wrong cause title. Not only these two persons, the rest of everybody has died.
So better you take necessary
No, the
steps.
plaintiff will have to take. I'm not the plaintiff. Now I'll answer this. So the entire petition, the cause title, all the parties.
Who is for the plaintiff?
After Mr. Mitro Miller,
But yes,
I will make my submission.
So defendant number 1, 2, 3, 4, and 5 all have died. As for the cause title in the petition,
Yes, petition ta dekhiye ekটু.
Lordship will kindly call for the record from the original side, the plaint. Today I say
Plaintiff is not here also today.
plaintiff has died.
No, learned advocate.
Substitution has taken
I
place.
am the applicant.
You are the applicant who want to be substituted.
Milord, after Mr. Mitro Miller.
Or you want to be intervened.
Now may I make this submission, Milord? This is
No,
Milord-
let the records be corrected.
Yes, but your lordship will
The
kindly
petition
hear
cannot
from
continue.
me. Kindly hear from me. Your lordship, Milord, has been shown the second line.
Yes.
In the one name must be added. That is the applicant here is Masood Duple. That name your lordship will find, Milord, at page 2 of the application.
Yes.
Now, Milord, this is a property.
Son of Suleiman Muhammad. Okay.
Yes.
No, question is you are an
Now the
applicant.
cause title.
Now, Milord,
You are
may
an
I
applicant.
come
You
to-
want to intervene or you want to substitute yourself.
Milord, I will be substituting. Now, may I explain this to your lordship?
Yes.
Milord, this is, Milord, a suit originally of 1940.
Yes.
Your lordship, Milord, has come across several suits which are, Milord, quite old, and from time to time the parties needs to be substituted because the nature of the suit is one of partition. This is the same case here. So, Milord, my learned friend's client is not having, my lord, any lesser right than me. We are sharing the same and equal rights. So before your lordship, my lord, the onus of giving effect to a substitution or amendment is equally shared by the parties. That's the first point. I do not stand in the way of, my lord, incorporating proper names, provided I am given, my lord, a proper and sufficient details of the parties who are, my lord, presently alive. Now, my lord, in all earnest, I came up before this court because of the death of the erstwhile party receiver. There is a dispute between the parties who are claiming to be the next receivers. My client says that I am having highest share, I should be. My learned senior counsel's, my lord, client says that she should be. Be that as it may, it is, my lord, falling for consideration before your lordship. At this stage, if your lordship calls for records, either of us, my lord, can take inspection and bring before your lordship the correct array of parties. That is point one. But, my lord, there is, my lord, one issue which is very, very important. That issue is, my lord, there are several tenants who used to, my lord, give the rent to the receiver who has died now. These tenants, my lord, are now in a disarray as to where or to whom they will be depositing the rent. If they start depositing rent before the rent controller, your lordship knows that the estate, which is only having an income less than 50,000 annually, will be jeopardized. That is the only point of urgency. These technical issues can be taken care. I'm sure my learned friend, my lord, or me would be advising our clients to incorporate the names and rectify the cost title. That needs to be done. So, my lord, for today, lordship will kindly, my lord, incorporate the corrections which has been suggested by, my lord, Mr. Mitra Lalit Singh,
the record.
and
The plain
also
be
add
brought
my
to
name.
the court. The
Yes.
plain be brought here.
Yes,
The-
yes, yes.
Then that
Certainly.
will clear the.
Whatever, my
plain
lord, has been
amended.
amended time to time, let that, my lord, be inspected by our
Lordship will see
advocates.
In 2014, orders is
So
IP
instead of Yusuf Ahmed Duple, it should be
No, Mala, there were several changes.
okay.
The
Record and order.
it has completely changed. In 2015, the last
advocate,
amendment took place.
Mr. Mitro, learned advocate appearing for
Lordship will see the name really kindly. Another thing, Malad. Lordship will kindly.
appearing
give
for
the
Fatima Khan.
Fatima Khan and Hasim Yusuf Mamsa.
Okay,
And I
Fatima
am
Khan
for Masood.
and Hasim.
Lordship will see the my lord's order, the appearance. My is correctly
Okay.
written in the appearance.
Learned
Below
that Mr.
21st of
Mitro,
July.
Learned
Below-
advocate.
Lord, I wish to
representing
make one
Fatima
submission.
Khan and Yusuf
Hasim Yusuf
Hasim Yusuf Mamsa. Mamsa
I'm appealing for
and
these two.
learned advocate representing the intervening applicant.
Applicant, my lord.
Applicant.
Right. Masood Duple. Alias
Applicant.
Masood Suleiman.
No,
My
should
name is
applicant
appearing page 2 of the application.
Masood Duple, who wants to intervene in this suit,
Lord, may I submit for a
are
moment?
present. Yes, you are.
Yes, my lord. My lord, I am, my lord, one of the I am one of the developers with
You're
which, my
leader.
lord, I am the only developer with which, my lord, the parties to the partition suit had entered into a development agreement in terms of the order passed by this honorable court.
Okay, learned advocate.
Well, he appeared for the petition on the last
Yes,
day.
yes, yes, I appear
now
for
he
the
has
petitioner.
turned court.
Developer is also.
No,
He is not a party to the proceeding.
This should
No,
be
no, I
corrected.
mean just recording his
Lot of
presence.
corrections requires in this.
And it's not that there's no
It is
conflict of
submitted by
interest.
Mr.
Why is
Mitro
Lot of
that
corrections is necessary.
the plaintiffs, the defendants in the instant suit have died.
Even the plaintiff.
everybody has
the,
died.
the defendants as well as the plaintiff in the instant suit has already died, and thus their heirs are required to be substituted by making necessary application. Thus, the plaint of the suit is called for. On the next day, the plaintiff is granted. This is a partition suit.
Yes.
Any party can make an application.
This is
But
Uh,
done. This is the
no,
order of
no.
IP Mukherjee.
No,
This
if
is
it is
IP
already
Mukherjee's
done,
order.
it is done.
2014 order. This has been done. Amendment has been carried out to the plain.
Further amendments are required, I
The
think.
problem of
Uh,
How do you know
Granted.
you're a developer? How do you know you're a developer?
Granted
not a party
liberty
to
to take out necessary.
That further amendments are required.
Parties are granted liberty to take necessary application if
Yes.
not already taken out.
This substitution has been allowed, carried out
Okay.
in
It
2015,
appears
order
from
2014.
order dated 1st July 2024 that an application for
2014.
substitute
2014.
1st July 2014 substitution
Death
order
record.
was passed by a coordinate bench of this court. Stop. Thus, this order and the amendment be carried out by the department if not already carried out. within a
as far-
period of,
I know it is done. It is
within a
done.
period of 3 weeks.
No, Lordship will call for the plaint
Acha.
because I know it's done.
Okay. Let
Otherwise,
be done.
otherwise, what
Let
Mr.
the-
Banerjee is saying,
let
that's
the
also
report
important.
be submitted
yes,
by the
yes.
department and the plaint be put off on.
Plaint be brought. Plaint aniye nahi ho. Plaint aniye na.
No, my lord, 4 weeks, my lord.
No, no,
kindly
4
keeps
weeks,
it-
that is
Keeps it,
छोटा
my lord, 10 days, my lord. I have expressed my disability, my lord. The rent is an
The-
issue over here.
No, no, but the amendment be carried out within 2 weeks. 3 এর জায়গায়। Let this
Amendment হয়ে
matter
গেছে।
appear on 20th August 2025.
20. No, but only another thing can be a leave to file the wakalatnama.
Okay, leave is granted.
Okay, difficulty is the cost chat. I don't have the cost chat.
So it's better the
I'm
department
not
submit a
opposed.
report with whether,
আমি জানি না কার নামে আছে এখন।
let the department submit a report with regard to the implementation of the order
Yes,
dated
then we'll
1st
get
July
the cost chat.
2014. And if not carried out, let it be carried out within a
Carry it
period
out
of
and
2
then we 20th we come back.
20th,
Mile.
along with the plaint.
Mile, along with the plaint. The plaint must be here. আর কি চাই? Plaint be produced, wrong cost.
And the plaint be put up
হ্যাঁ,
on 28/2025.
ঠিক আছে 20 তারিখ আসুন না 20 তারিখ আসুন।
My lord is calling for the. my lord,
Yes,
one
all the
liberty, my lord.
report with regard
Report and the plaint. Report and the
amendment,
plaint.
the plaint
Yes.
on 20th of August.
এই
My lord,
নামগুলো
one
ঠিক করে
single
দিচ্ছি।
liberty, my lord. My lord, the
এই নামগুলো-
advocates on record be given
নামগুলো দে।
liberty to at least inspect the record.
So let it come, let the report come. Asha.
So that, my lord, we know who are the parties and if there
Okay,
is any.
learned
necessary-
advocates may inspect the record.
Yes,
মাইল মাইল we will. আরেকবার লিখে দিন আরেকবার লিখে দিন।
28
বানানগুলো ভালো করে লিখে
না
দিন।
ওই একই টু বি মেনশনই থাকবে হ্যাঁ আন্ডার দ্য সেম হেডিং টু বি মেনশনই থাকবে
হ্যাঁ এত
to the learned advocates to inspect the records.
I'm deep lobby.
I have been given
Lord,
two
may the
briefs.
name of Mr. Alim be recorded. Lord,
Lord,
only
I-
for the
Yes, you
developer.
give the slip, it will be
Another
recorded.
detail. The developer can't be represented here.
I have two briefs.
Now he counts the people. Developer. Who is the developer? What is it? Look at the developer.
We shall file that
But
application.
if you have entered a development agreement, then you
Yes.
cannot prevent him from appearing.
No, that is by the
There
blessing of.
cannot be a partition suit.
That is by the
This
blessing.
is a partition suit.
Whatever it is, you during pendency of the suit, you have entered into an
I don't
agreement.
know that he.
So this picture should be brought before the court.
Absolutely. I bow down.
Item
No,
number
given
3.
the spelling correctly, you know.
হ্যাঁ এই নামগুলো ঠিক করে গিয়ে
হ্যাঁ।
Item number 3.
This is a matter where the preliminary degree
let
was,
me see the last order.
yes.
Yes, on 2nd August, it was on 2nd of August, the matter was fixed for report of the amicable partition. So what is the report of the amicable partition?
Lordship, that has not taken place. Commissioner has to be appointed.
Generally, it is made by not the application is being made for further statement. The application has not been made, but that has been recorded.
Okay, record an order. Learned advocates for the parties are present. It is submitted by the learned advocates that although the parties were granted opportunity or by order dated 7 July 2025 to enter into an amicable partition and submit the report, but the parties have failed to reach at an amicable settlement with regard to partition. Stop. In the facts and circumstances,
No, Lordship,
is-
then kindly come to 2nd August.
yes,
Then 2nd August, Lordship has recorded
okay.
that the appointment will be done.
No, 2nd August,
2nd August.
yes. 2nd August also, it's a simply adjournment.
No, 2nd August
Second,
because
kindly
that
come.
it has failed.
Okay, so sorry. It is submitted.
Para two.
It is also, it was also submitted by learned advocate for the plaintiff on 2nd August 2025 that partition commissioner is required to be appointed. Stop. Upon hearing the learned advocates and upon considering the facts of the case, this court is of the view that a partition commissioner be appointed. Thus, Dash is appointed as a partition commissioner. Learned partition commissioner shall hold a meeting with the parties and their learned advocates, and upon holding discussion with the learned advocates, take necessary steps to get the property partitioned by metes and bounds by appointing a
Properties.
survey commissioner.
Properties.
Yes, properties by metes and bounds by appointing a survey commissioner. Dash is appointed as the commissioner at the dash remuneration. The learned advocates and the parties are requested to extend necessary cooperation to the learned commissioner so that the suit can be disposed of expeditiously. Let this matter appear on 19th of September, 19/9/2025 for report of the learned commissioner.
HON'BLE.
Item number 4 and 5 for examination of judgment debtors.
I am for the degree holder, my lord.
Item 4.
Item 4.
4 and 5 analogously.
Analogous.
Yes, today is for the report.
My lord, today is for the report, but what happened, my lord? These are in the two matters, I am filing a preliminary report. The learned advocate of the decree holder have not submitted me the details of the learned advocates of the judgment debtor. I called them a meeting instantly. Mr. Abhimanyu attended the meeting. Then he assured me that he is going to give me. He has not done. Thereafter, I issued another notice, my lord. Even after acceptance of the said notice, they have not given me the details.
Give me a copy.
My lord,
My lord,
in the meantime, we tried to settle the matter out of court. In the
my lord,
meantime, we settled.
Lordship's leave, my lord, to intervene in this matter, my lord, on behalf of the state of West Bengal. My lord, I apologize, my lord, because of health reasons, my lord, I have not been able to be physically present before my lord. My lord, I'll request your lordship, my lord, to kindly keep this matter, my lord, after 3 to 4 weeks. My lord, I'll just in a nutshell tell my lord what is actually going on, and it will probably, my lord, shock your lordships. My lord, the plaintiff here, my lord, the Surana family, my lord, they run, my lord, they were running, my lord, a chit fund kind of an organization, and they are under investigation by the state of West Bengal.
No, did you file any application?
My lord, not yet, my lord. I am waiting for the papers, my lord. I need to, my lord, get the papers, and we'll file the application. And my lord,
No, but what is the difficulty if the judgment dated is examined?
No difficulty in, my lord, examination. Absolutely no difficulty.
I'm keeping the matter after 4 weeks.
Yes.
In the meantime, copy be served upon you. You come with necessary application. Let the examination of the judgment dated be complete.
Yes, my lord. But my lord, what is being done is, my lord, there is an act called the West Bengal Protection of Interest of Depositors in Financial Establishments Act.
So, you see, you come with your application. Let the examination of the judgment dated.
Lordship, we will do that.
One thing I've been informed, judgment data is not in city based. He is in Delhi.
Whatever it is,
Yes.
they will supply the address. Learned advocates for the parties are present. Mr. Muhammad Farauddin, who is appointed as a special officer in this matter, is also present. Learned special officer submits that in spite of the requests, the particulars of the learned advocates for the judgment dated is not supplied by the learned advocate for the decree holder, for which the learned special officer could not conclude the examination of the judgment dated. In the facts and circumstances, the matter.
My lord, we pray some time.
Yes,
We pray some more time.
Yes, I'm granting you. In the facts and circumstances, the matter stands adjourned till 3/9/2025. Necessary particulars be furnished by the.
Objection with regard to the application being filed by the.
It's a preliminary.
No, special officer has apprised the court. Yes, serve a copy.
I'll serve a copy.
Learned advocates for the parties are requested to give the particulars of the judgment dated. Let the inspection be.
May copies be served upon me, my lord. May copies be served upon me, my lord.
Copy be served upon Mr. Sinha, learned advocate for the state. Although Mr. Sinha has not made any application in this regard, liberty is granted to make necessary application on or before the next date fixed.
Grateful. Very grateful.
Judgment dated must be examined on or before 30th August 2025. Let this matter.
My lord, give a little more
Yes.
time. Give a little more time.
Yes, which one?
Give me more time.
I'm keeping it on 3rd of September.
No, he wants more time.
Why? He is going, your client is not coming. So by 30th August, it has to be completed. Let this matter appear on 3/9/2025 for report of the special officer. Other contents of the order dated 8 July 2025 remain unaltered. Yes, extend your cooperation so that the examination is completed.
Give me,
I'll send you a copy.
give me the copy.
I'll send you a copy by a covering letter because I have to give it.
I will acknowledge it, no
No,
problem.
let me, I'll
I
serve
don't
for
know
order.
what application-
I'll
my lord.
serve with a forwarding
What
report, the
application
copy in
I
course of
I
the
have
day.
the objection.
So you give them a
Kindly
copy,
record-
whatever you have filed.
Kind-
you give
whatever
them-
I'm
kindly
filing,
record
my
it.
lord,
I have objection with regard to
I
the application
will-
being filed and no.
I
copy.
Not filing any application, the report,
I
why
have
he could
filed-
not complete the inspection.
I have not filed anything. I've
He has
just-
filed a report, why this
with a
examination
forwarding
could
report,
not be
give me the
completed.
details, I'll send you.
Yes, you give him a copy.
Yes, my lord, I'll give it.
Sarvas also.
Yes, yes, yes.
What orders?
Item number 6.
My lord,
Day is fixed for hearing of this matter.
yes, my lord.
My lord, they haven't filed any affidavit, but this is the state's application not for intervention. Not we were added as a party on 1st July. Your lordship not permitted them to use an affidavit. Not by 15 July. Lord, no affidavit has yet been filed. My lord, this has to be heard before any other application can be heard.
Praying for 1 week time for the
All
time.
the 3 matters. Yes, sir.
And all the matters, my lord. In fact, my lord, items 6 to 8, and my lord, even the other matters, my lord, 10 to 12 and 16. My lord,
My lord, I am praying for time, 1 week time to file affidavit in opposition to the application filed by my lord, Law Enforcement, State of West Bengal.
and my lord, I will need my lord 2 weeks, my lord, to file a reply to that, my lord.
Okay. Item number 6, please record an order. Learned advocates for the parties are present as affidavit in opposition to the application GA. Yeah, what is the GA number?
238,
J 238, my lord.
38 of 2022.
It is your application.
No, their application.
My state's application. Yes, sir.
22 is not yet filed. Let the same be filed on or before 13/8/2025. Reply, if any, by 27/8/2025. Let this matter appear on 1/9/2025.
Yes, my lord. And not along with my lord, other items, my lord, being 7, 8, 10 to 12 and 16, my lord.
My lord, 7 and 8, my lord, your lordships heard that matter. On that day, my learned friend appeared.
Anyway, the affidavits are to be filed in this matter.
My lord, my lord, appeared on that day. My lord,
আচ্ছা ওখানেও এক কাজ করে দিন ওই সেম অর্ডার করে দিন
Yes, yes. Yeah. Best.
সেম অর্ডার
Lordship.
no, my lord, so far item number 10 is concerned, my lord, only report. 7 and 8.
টাইমটা হবে কল হবে
ওরা affidavit দিতে।
Item number 9.
9 টা হবে।
My lord, I am appearing on behalf of all the legal aids of defendant number 2, Shailendra Kumar Das. To raise
Yes, the order in one prayer is allowed. Let there be an order in terms of prayer A of the notice of motion dated 13th day of December 2024. And however, considering the submissions and facts of the case, this court is of the view that a special officer is to be appointed to conduct the following inquiry. So is appointed as the special officer to conduct the inquiry. The inquiry be completed and a report be submitted on or before 27/8/2025. So 27/8/2025 for report of the special officer.
7th of August.
27th of August. হ্যাঁ 27 তারিখে থাকবে ম্যাটারটা
New motion, item number 10, 11, 12 and 16.
Yes, this is their application. GA.
GA, my lord, 279, my lord, 278, my lord, your lordship was speech.
No, in all these, all these matters, affidavits are to be exchanged.
My lord, may I make one submission? My lord?
Yes.
My lord, in item number 16,
Yes.
my lord, in this particular GA, Justice Pottonak was pleased to pass an order whereby an ad interim order of injunction was passed in relation to the property mentioned in the GA. On that day, the intending purchasers to whom property was sold, they are strangers to the list.
You are representing whom?
Those intending purchasers who
Yes.
are, and my lord, in Justice Pottonak's order, the names of the three purchasers are mentioned. And
No, that is item 17.
16, my lord.
16. Okay,
And-
let me take this 10, 11 first.
My lord.
Yes, 10, 11, let it be same orders.
Yes.
10, 11,
Yes, my lord.
12,
12.
12. Okay, same order.
Yes.
Acha, item 16 and 17.
16, my lord.
16 and 17.
No, 17. No, 16 is 17 is different, but 16.
Okay, item 16. Let this matter appear on. Let this matter. Ageta kobe date diyeছি?
My lord, regarding item number 16,
Huh? Let this matter appear on 1/9/2025. I'm keeping it on 1st of September. Come with the particulars.
Very good.
one submission, the ad interim order was obtained by suppressing material facts by the applicant. And sometimes in July, the ad interim order was extended. On that day, the applicant was not present, but however, the ad interim order was extended pursuant to prayer made by some ghosts.
No, that is continuing till today.
Yes, but the applicant was not present on the day.
Anyway, come on 1st of September. I shall consider. Well, with necessary particulars.
Well, in this matter, I appear on behalf of the joint receiver.
My lord, the affidavits, we are yet to receive the affidavits, perhaps, my lord.
Item 16. Anyway, it will be taken up on 1st September. The other matters will be taken up thereafter.
My lord. My lord. My lord, let the interim order be extended.
Interim order is there.
Yes, my lord. Yes, my lord.
So let it be there. No.
My lord, it's perhaps expiring today, my lord.
My lord.
My lord, may I just
Hearing the matter, I cannot extend the interim order.
My lord, I humbly submit, fraud has been perpetuated before this honorable court
No, without
by
hearing,
the applicant and other parties.
without hearing, I can't extend. They come on 1st of September.
My lord, my lord will kindly see, let the matter, the interim order granted is extended for a period of 6 weeks. My lord will kindly take to that. My lord will kindly take up. My lord will look at my order for 1st July 2025. My lord will not kindly. My lord, if the interim order is vacated, my lord will see on what pretext the interim order was granted. My lord will kindly come. My lord's order.
They say pretext.
My lord. আমি করে নি আপনি তারপরে বলবেন
Give me order.
My lord will kindly my
Give
lord
me
will
that
kindly
order,
find my lord's order. My lord will kindly 1st July orderটা দেখান and my lord will see my lord's order dated 13 December. All my lord's order. My lord, here, my lord, affidavits they were supposed to file affidavits. My lord, none of the parties supplied affidavits, my lord. My lord, if the interim, I am stripped of the interim order, my lord, already my case is, my lord, my land is being usurped, it's being sold. My lord, Justice Banerjee's order has been misrepresented. I'll demonstrate the case, my lord, what has happened.
Okay, 1st July.
My lord, this is, my lord, 1st July.
978. Item number 16.
16, my
আচ্ছা
lord.
আইটেম 16 এ একটা অর্ডার রেকর্ড করুন তো ওই যে আইটেম 16 এ একটা অর্ডার বললাম না let this matter appear on 1/9/2025 the interim order granted earlier
My lord,
stands extended for a period of 6 weeks or till further orders which
My lord, I'm so grateful, my lord. By this, my lord's order.
Just 1 minute.
My lord, let him come with the affidavit, my lord, will do that.
in 1 minute. It will take some time.
My lord, let him come with the affidavit, my lord.
The applicant is not present on the last day, but the interim order was
My lord, is he
extended
casting aspersion?
to pursuant to whose prayer, if may I ask myself, was the interim order extended?
My lord, the name of the advocates are there, my lord. What is he saying?
The
My lord, this is a
applicant
change brief.
this applicant is not there.
Maybe his junior was there.
My lord, no, my lord. None of the names
My
appear.
lord will
All the
kindly.
names will appear.
তো নাম রয়েছে তো।
Yes, call the next.
Applicant
I am so
name.
grateful, my lord.
Item number 13 and 14.
Thirteen, yes,
13 and
not
14.
13.
My lord, item number 13 and 14 are my application, my lord. We are seeking a innocuous prayer upon the special officer to look into the matter. Whatever the fund is there lying with the register of original side, my lord, we have already taken a note from the register of original side regarding the fund certificate. I can hand it over, my lord.
This is pending from 2018.
Yes, my lord. And my lord, there was a direction to serve a notice upon the new special officer, Mr. Gopal Roy. We have already supplied the copy as well as the order, my lord. This is my affidavit service, my lord. My lord, today we can say one thing. My lord, kindly give me a special direction upon the special officer so that he can come forward. Because he is not appearing.
Okay, the matter appear on 17th July. You are representing whom?
My lord, the intervenor.
Intervenor.
Yes, ma'am.
Intervenor under what capacity?
My lord, we have filed applications.
Under what capacity? Are you a trustee or a Shebait
No,
or what?
my lord, we are one of the beneficiaries
Beneficiaries of?
of the deceased. My lord, kindly takes up my application GA number 8, cause title page number 2, Rajnesha Singh, Kapilesha Singh, the respondents. And we are the intervener, Katyani Devi and Diverani Devi.
Another application.
So have you served these persons, this Kapileshwar Singh and those Kam Sundari?
Earlier occasion, it has been served. If my lord was so pleases, my lord, we can serve again.
Better you serve
But
this
she give us specific direction upon Mr. Gopal.
special officer. Yes, yes.
New
These
special-
trustees should
Yes,
also
my
be
lord.
served.
Yes, my lord.
Yes, record an order. Learned advocate for the applicant intervener is present. Let notice of this application be served upon the trustees as well as the learned special officer. Let this matter appear on
Managing trustee.
Managing trustee.
21/8/2025. Okay,
My lord, item number 9 is this identical matter.
okay. I 909
GA number 9, item number 14.
14.
Yes, ma'am.
Okay, 14. Same order. Serve the trustees and the
Yes, ma'am.
special officer.
Yes, ma'am.
Adjournment, item number 15.
I'm appearing for the petition, my lord. I'm praying for 1 week's time, my lord, extension of time for
GA
filing a
5.
reply.
GA5.
We have
opposition.
we have also filed our opposition.
Your
my lord.
pleasure on the last occasion was to record that there are other GAs appearing that should be tagged with.
This is
What is this GA4? This GA?
My lord, this is for removal of the, my lord, Mutawalli.
And Nazir.
Mutawalli and
Appointed,
Nazir.
appointed.
What are the other GAs?
Other
Ashif,
GAs are from the
GA
single point.
1 and 2 is why my application. 1 is my application for removal of the Mutawalli, and 3 and 4 are on the same line, my lord, because those
My
were on.
application for removal of the Nazir and my confirmation of my appointment.
Yes, record an order.
Let all the GAs be tagged together.
Learned advocates for the parties are present.
May I file my affidavit in opposition?
Let the affidavit in opposition filed on behalf of
On behalf of the Nazirs, my lord.
of the Nazirs be kept with the record. You are to file a reply to this also.
Yes,
Well, I have filed it with the department.
Let affidavit in reply be filed on or before 20th August 2025. Let this matter appear on 25/8/2025. Let GA1 of 2025, GA2 of 2025 GA and 4. GA 3 of 2025 and GA 4 of 2025.
2025, my lord.
GA 1 is of 23, my lord.
Okay, let GA 1 of 2023.
Let my application come separately, my lord. Let their application.
Let them appear. Just let it appear. Otherwise, it will not be hard out.
Very well.
It touches the similar point.
Okay. GA 1 of 2023.
23.
And GA 2?
23.
2, my
GA
lord.
2 of 2023.
Yes.
GA 3?
GA3, my lord, is of
2024,
No,
I believe.
GA3. Just a minute.
GA4 is of 24
GA4 is 24.
and GA3, my lord.
GA 4 of 2024. And GA 3 of?
GA3 of 23, my lord.
Of 2023 be listed along with this application. You serve a copy upon Mr. Ahmed.
Yes, my lord. Let me be favored with the copies.
Yes. Let copy of this application be served upon Mr. Ahmed.
That's correct. Grateful. I am grateful.
My lord, we will also, sir, lordship records that we have filed the opposition with the department, my lord.
No. The applications which you are asking for tagging, those copies.
Okay. On and four. And these opposition have served copy upon Mr. Ahmed.
Mr. Ponchishar.
My lord, on behalf of the Mutawali, my lord, we already filed it with the department. Lordship kindly record that and have served a copy upon Mr. Ahmed.
Ahmed, yes.
Grateful, man.
Great.
My lord, one indulgence, my lord.
Yes.
That I have filed my opposition, lordship kindly records and I have
Okay, the
Mutawali.
affidavit in opposition filed in the department be also put up.
My lord.
Item number 17 and 18.
Item 17 and 18, your lordship.
I appear for the petitioner.
I am, your lordship, the executors of the will, your lordship. In the meantime, two applications were filed. One is GA 3 of 2024 and the other one is GA 4 of 2024. Now, GA 3 of 2024, your lordship, is an application for appointment of an administrator pendente lite. Now, your lordship, the two executors are there. One is, your lordship, the daughter of, your lordship, the testator, and the another one, your lordship, is the family friend. Now, the second application is in connection with section 340 of the Criminal Procedure Code. Now, why they have filed it, the main basic reason is that the testator left behind certain shares. And
whose application is this?
No, these are my
application by
application.
the caveator.
On the last occasion,
You have
my lord, we had
concluded your argument?
Yes.
I had concluded my arguments in respect of GA3. GA4, my lord, can be taken up later. GA3, my lord, was hearing. GA3, I have concluded my arguments.
So you submit with regard to GA3, what you have to say?
GA3, that's exactly I'm submitting, your lordship. GA3, your lordship, is an application for appointment of an administrator pendente lite. Now, why I'm saying, your lordship, the GA4 is also connected, because, your lordship, the factual basis is same. On that basis in which, your lordship, the GA3 has been filed. Now, their main contention, your lordship, is at the time of the death, the testator left behind certain shares. And suddenly, your lordship, this is the cause of action in connection with the application, that suddenly they basically they applied before, your lordship, the depository recipient, and, your lordship, they have come to know that now, your lordship, the certain shares have already been transferred in favor of a third party, and only a very nominal shares are left. So that's why they are basically saying that no, the executors have not done proper acts, and for that reason, an administrator pendente lite is required to be appointed.
What is your affidavit in opposition? Let me
Yes,
see.
your lordship. I'll show the affidavit first, but before that, I want to show their cause of action, because in the affidavit, what I have disclosed, your lordship, this particular issue, your lordship, regarding, your lordship, how these particular shares were actually handled by the nominee, because the nominee was the wife of the testator, Mr. Shashi Murarka. The testator is Bhagirath Murarka, and the testator's wife is, your lordship, the Shashi Murarka. Now, Shashi Murarka was the nominee of those particular shares. Now, in 2008, which has been deliberately suppressed in the application for appointment of administrative pendente lite, a suit was filed by the same person before the Alipur court. And, your lordship, the reliefs were identical. because the caveator was claiming right in connection with these shares. 2008, he was contesting, or rather, your lordship, this suit has been filed and I was contesting there, and each and every fact, your lordship, I have disclosed along with my written statement from 2008. Now, after the filing of the written statement, your lordship, both parties have adduced evidence. Examination, cross-examination was going on. This said suit is reserved for judgments. Now, in the meantime, this particular application has been filed only for the purpose, your lordship, to avoid the finality in connection with that particular suit. The facts which were known to him has subsequently in this application has been mentioned that suddenly they have come to know that where the shares are. Your lordship, everything I have disclosed in the written statement, because I have also been pleaded as a party in that particular suit. They knew very well, and subsequently, suddenly, your lordship, today the application has come before the Honorable Court. I'll show my affidavit in opposition, but prior to that, your lordship, I would like to show his own application and how he has suppressed this. Now, things are, he's a son. Now, your lordship, what he has done, that there was a mutual distribution of the assets. Now, all the properties he has taken. Shashi Murarka was the wife of the testator. The grandsons are with us. The entire shareholding, the nominee, your lordship, has actually framed a trust, and the grandmother, who is no more, has given to the grandson. He is trying to take the various litigations, civil, criminal, everything has been done by him. He filed a suit in Alipur court. Isn't it a duty, your lordship, to at least tell that particular fact before the Honorable Court? I was shocked, your lordship, even the learned advocate has not addressed. Lordship, I am showing your lordship my affidavit in opposition, but prior to that, your lordship, kindly take his application and what is his cause of action. Because in testamentary matter, your lordship, unless and until he shows that the executors have not done their acts properly, then in that case, your lordship, usually the testamentary court, your lordship, does not remove the executors and appoint an administrative pendentality. Because the reason is section 211 of the Indian Succession Act clearly says that once the testator has appointed someone as a executor, unless and until the executors are doing something contrary to the wishes of the testator, that's why, your lordship, section 247, the word may has been incorporated. So it's a complete discretion of the court. Now let's see, your lordship, what is his application and on what basis, your lordship, he has filed this application before this Honorable Court. And moreover, what he has done, he has filed a 340 against his own sister, Nisha Singhania. And moreover, why he has filed this particular 340, very, very interestingly. Now, your lordship, when I filed, your lordship, the application for grant of probate, the first and foremost thing, your lordship, I had to file, your lordship, the affidavit of assets. But affidavit of assets, I cannot delete some of the assets and include it. I have to give all the assets in connection with the
within your knowledge.
I had within my knowledge and at the time of the death of the testator.
Yes.
Whether that has gone subsequently transferred, that's not the thing. Being an executor, what is in my knowledge, I have to give in entirety. Now, your lordship, kindly see his application, that is GA3 of 2024. I am not showing the prayers. Your lordship, is very short application. Your lordship, kindly take that application. And let's see how many facts and material facts he has deliberately suppressed. Lordship, kindly take, your lordship, paragraph 3. The testator being Bhagirath Murarka died on 5th September, should be fit, it's mentioned as 13th, and is presently survived by the following heirs and the legal representative, Praveen Murarka. Lordship, the application, I'm showing the application, GA3.
Yes, which page?
Your lordship, kindly see page number 2. It's very short application. I would like to show your lordship what is his cause of action today.
Yes.
Paragraph 3. The testator being Bhagirath Murarka died on, it should be 5th, you have written 13th, and is presently survived by the following heirs and or legal representative. Praveen Murarka is the applicant here. And Nisha Singhania, your lordship, is the one of the executors in the will. After the death of the testator, the plaintiff being the executor of the will dated 20th October 2001, filed the instant probate application being PLA number 287 of 2007, inter alia praying for grant of probate of the said will in favor of the plaintiff in respect of all the assets to have been left behind by Bhagirath Murarka being the father of the defendant. Probate application, Your Lordship, has been annexed. Subsequently, on or about 16th December 2008, the petitioner herein received a citation from this Honorable Court, thereby inter alia directing the defendant to appear in the proceedings. Thereafter, on 24th December 2008, the petitioner entered appearance by filing an affidavit in support of caveat, thereby denying the case as made out by the plaintiffs in PLA number such and such. As a result, the said probate application becomes contentious in nature and thus converted into a testamentary suit. The said testamentary suit, the said probate application now converted into testamentary suit discloses that the deceased Bhagirath Murarka was a Hindu governed by Mitakshara School of Hindu Law, who died on 5th of September 2002, appointing the plaintiffs as executors of the will. It is pertinent to mention that Bhagirath Murarka owned shares of considerable value both in individual as well as Bhagirath Murarka HUF, which is evident from the demat statement of Vedika Securities Private Limited. Vedika, Your Lordship, is the depository. Now, Your Lordship kindly sees, however, the said shares belonging to Bhagirath Murarka HUF was wrongfully included in the affidavit of assets filed by the plaintiff in their probate application. The petitioner was thus compelled to raise their claim over the shares of Bhagirath Murarka HUF with a representation dated 27th of December 2004. The petitioner continued to state objections to the same with response from the said nexus. Now, Your Lordship kindly sees 2004 and 2023. There is a gap of 19 years from paragraph 7 and 8. Now, at this juncture, upon receiving a letter on or after 16th of July 2023, the petitioner was shocked to learn that on 10th July 2023, the statement of holding of late Bhagirath Murarka shows only 300 DSQ software equity shares in account of the testator. All the other shares as shown in the demat account as on 5th of September 2002 were fraudulently transferred, sold or disposed of in due course of the time to deprive the defendant, knowing fully well that some of the shares belongs to Bhagirath Murarka HUF, and it is not permissible in law to transfer, sold or dispose of any assets without taking a probate of the purported will, the will dated 20th of October 2001. Thereafter, Your Lordship, he has annexed one letter of Vedika Securities Private Limited, that is at page 95. Now, the defendant states that all shares and other assets of the testator, which is the subject matter of the instant suit, have been transferred with full knowledge and consent of the plaintiff to deprive the petitioner of his lawful claim of the shares of Bhagirath Murarka. The defendant states that there would be clear violation of law as well as the directions of the testator in the event that the plaintiff's being the executor proceeds to fraudulently transfer, sell or dispose any further shares of the testator and distribute the same amongst themselves before grant of the probate of the will of the deceased. So this is his cause of action, that I have done the fraudulent transfer. Now, Your Lordship kindly sees paragraph 10. The deponent states that the plaintiff executors have failed to take appropriate steps to protect and or act in the interest of the deceased testator even after being put to knowledge of the above irregularities, and thus have failed to discharge their duties to the executors of the estate of the deceased in a fair and transparent manner. The deponent states that the executor of the said will and the deceased, instead of taking steps or expeditious disposal of the present proceedings, took steps contrary to the terms of the will and fraudulently transferred, sold and disposed the shares of the testator. The executors are acting contrary to the wishes of the testator and are fit to administer the estate, and by reasons stated herein above, both the said persons are not fit to be appointed as an executor of the estate of the deceased. And therefore, paragraph 13, the deponent is a fit case where an administrative pendentalite be appointed by this honorable court under the specific provision of section 247 of the Indian Succession Act, who shall have the powers as the general administrator to administer the estate left behind by the deceased, subject to the immediate control of the honorable court, and to pass order of injunction do issue directing upon the executors, restraining them from transferring the further shares or valuables or assets belonging to the deceased until the disposal of the suit. The defendant states that the majority of the shares in the demat maintained with Vedika of the National Securities Depository Limited have been siphoned away. So it is expedient and in the interest of justice that the shares left in the demat account are to be preserved and protected under the will. So this is, your lordship, the cause of action they have made. So the executors have done fraudulent tax, and that's why they should be removed. And your lordship, the administrative pendentalite should be appointed. What has not been disclosed, your lordship, kindly see my affidavit. And now your lordship sees that how your lordship, this particular application, your lordship, is misleading and fraudulent. Lordship, kindly take my affidavit in opposition. So before your lordship showing my pleadings in my, your lordship, the affidavit, your lordship, kindly take page 20.
Page 20.
Yes, your lordship.
Yes. Yes.
Lordship, kindly take page 20. Lordship, Mr. Mukhopadhyay, your lordship, I am showing your lordship that how a son should act, your lordship, to the mother and the father and the sons. Lordship, kindly take page 20. Before that, your lordship. Yes, your lordship. Before that, your lordship, kindly take once page 90. Because I want to show this, because how many litigations, civil and criminal? 19. 19, your lordship, is the annexure A. This is the list of cases between Murarkas and where
matrimonial suit is also mentioned.
Yes. Matrimonial suit, your lordship, has been filed against your lordship, the wife. His wife is fighting with the mother, is fighting with the father, is fighting with the wife, is fighting with the sons.
It is and not that's necessary to bring this matrimonial suit in this probate proceeding.
No, I want to show your lordship, I want to show that how many proceedings he has done, but he could not get anything. Now, your lordship, kindly take page 20.
Yes.
Your lordship, kindly sees the cause title. No whisper about this particular suit. Kindly see the cause title, your lordship. Bhagirath Murarka HUF, represented by Praveen Murarka. Our contention was there was no HUF at all. But good, bad, indifferent, he has tried to represent the Bhagirath Murarka HUF, but represented by Praveen Murarka as Karta and sole surviving member of HUF. So therefore, your lordship, in Hindu undivided family, there has to be members. So he is trying to say he is the sole surviving member of that particular HUF. Now, your lordship, kindly sees who are the parties here. Kindly see, your lordship, page 22. Nirja Ratheria, who is one of the executor, your lordship, is a party. Defendant number 4. Defendant number 4, your lordship, Nirja Ratheria, she is a doctor. Nirja Ratheria is the defendant number 4. Nisha Singhania is the sister. She is also impleaded as a party. Now, your lordship, kindly sees. Even the Vedika Securities, your lordship, is also impleaded, your lordship, as the pro forma defendant number 9 at page 24. Now, before that, your lordship, kindly take page 23. Even he is impleaded, your lordship, sons also a party in this suit. Abhishek Murarka and Akshay Murarka, your lordship, kindly see, sons of Praveen Murarka. So a comprehensive suit, your lordship, they have filed before your lordship, the Alipur court. Now, your lordship, kindly sees. What are the prayers? Kindly take page 36. Page 36, your lordship, kindly come. Internal page 60. For a declaration that the shares and jewellery described in Schedule A and Schedule B herein under respective belongs to Bhagirath Murarka HUF and Shri Praveen Murarka being the sole surviving members of HUF is entitled to the shares. For further declaration that all the transfer made by the defendants of Bhagirath Murarka HUF, more particularly described in Schedule A and Schedule B hereunder, are illegal and invalid. Page 37, Your Lordship, he has asked for also for accounts an appointment of a receiver to take possession. Prayer D, Your Lordship. For appointment of a receiver to take possession of the shares and jewelleries described in Schedule A and Schedule B hereunder, permanent injunction restraining the defendants in dealing with the shares and jewelleries described in Schedule A and Schedule B properties. Now, Your Lordship, kindly see, Your Lordship, what are the schedules. At page 38. Now, page 38, Your Lordship, the list of the shares he has mentioned.
Yes.
Now, Lordship, kindly sees page 40. Page 40, Your Lordship, is the affidavit of Mr. Praveen Murarka. So, he cannot say that he had no knowledge regarding this particular suit. Page 40. Now, Your Lordship, kindly take, Your Lordship, what is the cause of action in connection with this particular suit. Lordship, kindly take page 35, internal page 15, paragraph 21. Paragraph 21, Your Lordship, kindly sees the cause of action arose on 13th October 2006, when Shri Praveen Murarka, the sole and surviving members of the said HUF, came to know that the transaction of the shares of late Bhagirath Murarka and Shashi Murarka, who is the mother, who lived and died at 1/C Mandevilla Gardens, PS Goriahat, Kolkata 19, where the shares, which are the subject matter of the suit, were dealt with, and the learned court has both territorial and pecuniary jurisdiction. So, therefore, his cause of action is in 2006, the mother was dealing with these particular shares. And that's his cause of action in the year 2008. So, he can't say today, Your Lordship, that he had no knowledge in connection with these shares. Now, Your Lordship, we filed a written statement disclosing everything, that how this particular share of Bhagirath Murarka, the mother was actually dealing with.
So this is reiterated in this application also, probably.
Suppressed, Your Lordship, in this
Okay,
application.
para 21?
No, suppressed, completely suppressed. This application is liable to be dismissed with heavy cost, Your Lordship, so that they will not dare, Your Lordship, to come before the High Court and file this type of frivolous applications. Now, Your Lordship, kindly see my written statement. I filed the written statement as a contested suit there. Lordship, kindly take page 155. It starts from page 152, second volume. Now, Your Lordship, before showing Your Lordship the written statement, I would like to show the affidavit portion. Your Lordship, kindly take page 180.
Page 180.
Page 180. And Your Lordship also sees page 179. This written statement was filed sometime, Your Lordship, in 2013. Page 179, Your Lordship, kindly sees.
Yes.
4th June 2013. So, therefore, since 4th June 2013, you had knowledge regarding each and every facts. So, from 2013 till today, we are in 2025, and this application has been filed in 2024. These entire facts, you had knowledge, evidences has been adduced, examination, cross-examination done. Now, Your Lordship, kindly sees.
With your copy.
J4
G3. G3. This is what was
তো মজার সঙ্গে ম্যাচ করছে তোমরা দিয়ে দেবো কপি বলো সেটা বলতে হবে
Now, Your Lordship, kindly take page 155, where I actually, Your Lordship, my written statement starts. And Your Lordship, the factual basis, Your Lordship, I have shown at page 158.
Yes.
Page 158, on or about 27 June 2000, the father of the plaintiff, Bhagirath Murarka, since deceased, had applied to the defendant number 9, inter alia requesting to open an individual beneficiary's owner's demat account with the defendant. The copy of the application, Your Lordship, I have annexed. I'll show that also. Pursuant to such request and upon execution of a formal agreement on 27 June 2000, the defendant number 9 duly opened an individual beneficiary's owner's demat account in the name of Bhagirath Murarka, being client number such and such. A copy of the agreement dated 27th of June 2000 is also annexed. The said Bhagirath Murarka duly nominated, very important, Your Lordship, kindly sees. The said Bhagirath Murarka, since deceased, duly nominated his wife, Shashi Murarka, as his nominee in the said demat account, as would be evident from annexure A and B hereto. Actually, I'll show Your Lordship that the wife, Your Lordship, has been implemented, or rather, Your Lordship, incorporated as a nominee, Your Lordship, in connection with annexure A. Lordship, kindly take page 185 once. This is the application of Your Lordship Bhagirath Murarka to Vedika Securities Private Limited.
Yes.
Page 185. Bhagirath Murarka, Your Lordship, the name of the holder is mentioned. Now, Your Lordship kindly sees page 186. The signature of Bhagirath Murarka is mentioned in the bottom. And Your Lordship kindly take page 188. Page 188, Your Lordship, is the name and address of the nominee. Now kindly see Shashi Murarka. She was the wife. So her name has been shown as, Your Lordship, as a nominee in connection with the demat account of Your Lordship Bhagirath Murarka. Now, Lordship, kindly take again one page 158. Subparagraph 3. C. The said Bhagirath Murarka died on 5th of September 2002, leaving behind him surviving Shashi Murarka, wife, Praveen Murarka, son, and Nisha Singhania, daughter, as his only legal heir. For a considerable period of time running into several years, the relationship between Bhagirath Murarka and his son, the plaintiff, was extremely strained. The plaintiff and the said Bhagirath Murarka, since deceased, were not on good terms and did not carry on business together. In fact, in or about 1998, the plaintiff and his father, the Bhagirath Murarka, started living separately and also having separate mesh and worship, and they had separated from each other, having their own independent lives and income. The plaintiff's mother, Shashi Murarka, resided with her husband, that is Bhagirath Murarka, since deceased. For several years past, the relationship between the plaintiff and his only sister, that is the answering defendant number 5, has been extremely strained, and the plaintiff and the wife, Sharmila Murarka, have also separated from each other and are living separately for long years. A decree of divorce between the plaintiff and the Sharmila Murarka has already been granted by the learned court. The plaintiff's only 2 sons, that is defendant number 6 and 7, also live separately with their father, and the relationship between the plaintiff and the 2 sons, the defendant number 6 and 7, is also strained. The plaintiff does not enjoy good relationship with the members of their immediate family and even extended family. Prior to his death, the said Bhagirath Murarka had executed his last will and testament dated 20th of October 2001,
a copy whereof is annexed here and marked C. By the said will, the said Bhagirath Murarka appointed the answering defendants as executrix to the said will, entitling the answering defendants to act jointly and or severally. The answering defendants have duly applied for grant of probate of the said will, which is pending before the Honorable High Court at Calcutta, being PLA 287 of 2007. Though the plaintiff had duly given his consent to grant of probate of the said will, the plaintiff subsequently filed a caveat in PLA 287 of 2007 in connection therewith. An affidavit of consent affirmed by the plaintiff on 19th of November 2004 is annexed here to and marked D. So initially what he has done, he has given a consent, your lordship, affidavit, which I have also annexed. I'll show that. The said application for grant of probate of the said will has been wrongfully contested by the plaintiff, and as such, the same has been converted into a suit which is pending. By the said will dated 20th of October 2001, the said Bhagirath Murarka, since deceased, bequeathed the valuable tenancy rights in connection with the office space as 7 Lions Range, Kolkata, as also the furniture, fixture, telephone, etc., lying in the said office in favor of the plaintiff. The said Bhagirath Murarka bequeathed all his properties and assets, including bank balance, shares, and investment, to his wife, the said Shashi Murarka, absolutely and forever. Upon the death of said Bhagirath Murarka, his wife and Shashi Murarka issue a letter dated 10th of September 2002 to the defendant number 9, informing the death of the said husband and requesting all shares, debentures lying in the said demat account of Bhagirath Murarka be transferred in her favor, because she was the nominee. Now your lordship kindly sees lordship kindly take page 201. Lordship, this is a letter dated 10th of September 2002.
I think this will continue. Let me release the other matters till recess. Hey, recess of the onno matter gulo release kore do. Other matters be released till recess. Now recess of the. And except this matter, other matters be released till recess. এই ম্যাটারটা ছাড়াও অন্য ম্যাটার গুলো রিলিজ করে দিন, রিসেস অবধি, আবার রিসেসের পরে আবার নেওয়া যাবে। Yes.
Yes, Lordship. Lordship, kindly take page 201. This is a letter dated 10th of September 2002 from Your Lordship Shashi Murarka. And she is writing a letter to the Vedika Securities Private Limited. Subject is transmission of Mr. Bhagirath Murarka. Your Lordship kindly sees, I am sorry to inform you that my husband Bhagirath Murarka has expired on 5th of September 2002. He is holding the above mentioned account with you, in which he had nominated me as his nominee. Hence, I request your good self to kindly transfer his holding into my demat account. Please find enclosed death certificate, notarized affidavit, and annexure road duly filed up as requested for the process. The above given is for your kind perusal. Kindly acknowledge. So during the lifetime being the nominee, she applied before Vedika Securities for the transfer of the shares in her own demat account. Now your lordship kindly sees also page 197. The affidavit which he has given regarding the consent, he has a right to do it, no problem. But initially your lordship, he has given an affidavit regarding your lordship the father's will. Annexure D, page 197. I, Praveen Murarka, son of Bhagirath Murarka, since deceased, resided at such and such. I am the only son of the testator above named. The testator above named, who was a Hindu governed by Mitakshara School of Hindu Law, died on 5th of September 2002 at Woodlands, in the town of Kolkata after duly publishing his last will and testament in English language and character dated 20th of October 2002, whereby he appointed Dr. Nazir Atheria and Srimati Nisha Singhania, the petitioner, as the executrix of the will, entitling them to act jointly and or severally. Now, page 198, Your Lordship kindly says. The said Dr. Nazir Atheria and Nisha Singhania proposes to apply for grant of probate of the said will in their favor, and for this purpose they have prepared a petition which has been shown to me. Due execution of the said will would be proved by the joint affidavit of the said Nazir Atheria and Nisha Singhania being the two attesting witnesses of the said will, as they by their declaration signed at the foot of the said petition. The testator above named left properties both within and outside the original jurisdiction of this court. I am only the 3 heirs of the testator, namely whose name will appear. So 3 names are mentioned, Your Lordship: Shashikala Murarka, Praveen Murarka, and Nisha Singhania. Now should kindly see paragraph 7. I have no objection whatsoever to the said Dr. Nazir Atheria and the Srimati Nisha Singhania being appointed as the executors and trustees of the will of testator Bhagirath Murarka since deceased, and duly acting in terms of the will and probate thereof when granted in their favor. And lastly, Your Lordship, it is therefore desired by me that the probate of the will be kindly granted to the said Nazir Atheria and Srimati Nisha Singhania as prayed for in their petition for grant of probate. So this is the affidavit, Your Lordship. He has actually affirmed, Your Lordship, before the Honorable High Court, which subsequently, Your Lordship, he has said. And they have, Your Lordship, annexed this particular affidavit also in their petition at page 38. In their application, Your Lordship kindly sees. In GA3 page 38, the same affidavit, Your Lordship, they have annexed. So they had knowledge, Your Lordship, regarding this affidavit also. Now, Your Lordship, kindly take, Your Lordship, my affidavit in opposition, page 161. Page 161 is a part of the affidavit, Your Lordship, part of the written statement, internal page 10.
Yes, 161.
161. Pursuant thereto, on or about 17 September 2002 and 22nd September 2002, the defendant number 9 duly transferred the entirety of the shares except one share which was in a pledge account held by Bhagirath Murarka under client number such and such to the demat account of Shashi Murarka being client number such and such, along with defendant number 9. Particulars of the shares, debentures, etc. transferred from the said demat account of the said Bhagirath Murarka to the demat account of Srimati Shashi Murarka are set out in a schedule and annexure F. So I have given the entire details of the shares in the demat account. Shares in the demat account which has been transferred from the Bhagirath Murarka's demat account to Shashi Murarka's demat account in the year 2013. Now, prior to the transfer of the shares, debentures, etc. in her demat account, the said Shashi Murarka, in her own individual capacity, held shares of various companies in her personal demat account. And I have also given the particulars of those particular shares which Shashi Murarka was holding in her individual capacity also. So the two statements I have disclosed with Your Lordship in the particular suit before the Alipur court, that is annexure F and G. Now, On 9th of March 2004, the state Shashi Murarka created a trust by the name of Bhagirath Shashi Murarka Foundation, which is, Your Lordship, the defendant number 1 in this particular suit. On 9th March 2004, the state Shashi Murarka created a trust by the name of Bhagirath Shashi Murarka Foundation. The defendant number 2 and 3 were appointed as trustees of the said trust. At the request of Srimati Shashi Murarka, the defendant number 2 and 3 accepted to act as trustees with the confines of the said deed of trust dated 9th of March 2004. In terms of the trust deed, during the lifetime of Shashi Murarka, the trust fund was to be used for her benefits, her maintenance, her expenses for medical treatment and household expenses, as also for the education of 2 grandsons. The defendant number 6 and 7, both sons of the plaintiff. The trust deed further provided that upon her death, the defendant number 6 and 7 were to be the absolute beneficiaries of the trust fund. During her lifetime, the said Shashi Murarka purchased and sold shares of various companies. Out of the amounts received by the said Shashi Murarka from the sale of the shares, substantial sums were utilized for her maintenance, upkeep, and medical expenses, and the balance sums were converted into fixed deposits and the investments in mutual funds in their personal name. During her lifetime, the said Shashi Murarka also executed 2 gift deeds dated 30th June 2004 and 26th July 2004, whereby the said Shashi Murarka transferred a substantial portion of her shares in the favor of the trust, that is the defendant number 1. Copies of the deed of gifts dated 30th June 2004 and 26th of July 2004 are annexed here too. And particulars of the shares transferred by the said Shashi Murarka to the defendant number 1 are set out in a schedule. So we have also given Your Lordship the schedule of that particular trust. The said Shashi Murarka died on 11th of May 2007, leaving behind her will dated 22nd of January 2005, whereby she appointed the defendant number 4 and 5 as the executrix of the said will, entitling them to act jointly or severally. A copy of the will of Shashi Murarka has also been annexed. Now, by the said will, the said Shashi Murarka, since deceased, did not make any bequest in favor of the plaintiff, save and except an idol of Lord Krishna. At the time of her death, the said Shashi Murarka was the absolute owner of the shares. Particulars we have given. After the death of Srimati Shashi Murarka, the shares belonging to the said trust, the defendant number 1, were duly transferred to his 2 beneficiaries, namely the defendant number 6 and 7, who are the grandson and the sons of the applicant, in accordance with the provisions of the said trust deed. The answering defendants have not been bequeathed any movable or immovable properties. Your Lordship, Neeta Shingania, she is the daughter of Shashi Murarka, but the mother has not given anything. To the daughter doesn't matter because the grandsons are theirs. They have to take care of, Your Lordship.
The grandsons from the daughter's side.
No, from the son's side.
From the applicant's side.
From the applicant's side. That is defendant number 6 and 7. But actually, Your Lordship, the defendant Nisha is basically a PC of Your Lordship. Because father, Your Lordship, the applicant's sister Nisha, Your Lordship, and the sons, your grandsons, are Pravin's 2 sons. Because he has separated, Your Lordship, he has given divorce to the wife also. So the Bhagirath Murarka, Shashi Murarka, Your Lordship, the grandfather and grandmother, Praveen is the applicant here.
And the Nisha.
Shormila is the wife.
Nisha is a sister.
Nisha is sister of Praveen and the 2 grandsons. So basically, Your Lordship, now today why I am showing this, because these particular facts, they had knowledge in the year 2013 because they filed a suit in 2008. If that is the case, Your Lordship, where is the cause of action in filing an application for an administrative pendente lite before this court? And the most important thing, what they have done, I'm not saying I'll make my legal submissions, Your Lordship, in connection with GA4. But what they have done, what they have said, that if you had knowledge regarding everything, why you have filed an affidavit of assets of the Bhagirath Murarka showing these particular shares? I had to do it because I have to give the entire shareholding or regarding the movables or immovable properties which the deceased left at the time of the death. That's, Your Lordship, the original side rules or your lordship, the Indian Succession Act says so. And on that basis, if he's filed also a 340 against me, my own sister. Now, your lordship, kindly take, your lordship, the annexure, subparagraph Q. Page 163. After the death of said Shashi Murarka, the shares belonging to the said trust, that is the defendant number 1, were duly transferred to his two beneficiaries, namely the defendant number 6 and 7, in accordance with the provisions of the said trust. The answering defendants have not been bequeathed any movable and immovable assets or property by the said Bhagirath Murarka and or by the said Shashi Murarka. The said Bhagirath Murarka hath bequeathed his entire shareholding to his wife, the said Shashi Murarka, who utilized a portion of such shares for her maintenance, upkeep and medical expenses, and transfer the balance of the said trust for the benefit of her grandsons. The said grandsons, defendant number 6 and 7, have duly received the assets lying in the name of the said trust. The plaintiff has been continuously, habitually and repeatedly harassing the answering defendants, his sons, his wife, and the other family members. Several proceedings have been initiated by the plaintiff to harass and intimate his family members in an attempt to somehow illegally pressurize the defendant number 6 and 7 into parting with a portion of the shares that is received by them from the said trust. It is evident that the plaintiff is interested in denying and depriving his own sons from their lawful inheritance. The plaintiff has wrongfully and illegally sought to raise disputes regarding the transfer of the shares in favor of his mother, the said Shashi Murarka, for the first time on 17th August 2006, and started making false and frivolous complaints against the defendants, and or some of which the defendant number 8. All such contrary complaints and allegations are false, frivolous, baseless, and absurd. In the present suit, the plaintiff has purported to challenge the transfer of the shares which took place even according to the plaintiff's own admission in the year 2002. In the premises, the suit filed by the plaintiff purporting to challenge the said transfer of the shares and the purported claim of the plaintiff in relation thereto is hopelessly barred by law of limitation and no relief can be granted. Now, prior to that, your lordship, I would also like to show, because they were actually shocked to see, your lordship, regarding the letter given by Vedika Securities, and that is, your lordship, their cause of action. Now, your lordship, kindly see that particular letter once. Later to the lordship, kindly take page 95 once. Page 95 of the application. Yes. Page 95, your lordship, is the letter given by the Vedika Securities, your lordship, in the year 2023. Because that is their cause of action, that from 2004, there is a gap until 19 years, and suddenly, your lordship, their pleadings in the application shows that 2023, they have got this letter, and that's why the entire problem started, and that's why they want an administrator pendentality to be appointed by this honorable court. Kindly see the letter itself, your lordship, that is dated page 95, your lordship, kindly sees reference your letter dated 27th of June 2023. This letter, your lordship, they have not annexed anyhow, your lordship. We presume, your lordship, this reply actually has come. With reference to the aforesaid letter submitted to the investor cell of NSDL, please note that we haven't received any request or letter regarding the requirement of the letter statement from your end. We have provided you the holding statement of late Bhagirath Murarka in the year 2018. We have provided, your lordship, we have provided you the holding statement of late Bhagirath Murarka in the year 2018 based on the letter received from your end at that point of time. So therefore, he can't say that first time he has come to know in 2023. So this is again a misstatement. Lordship kindly sees. As desired by you, we are enclosing the latest statement of holding as on 10th of July 2023 of Shri Bhagirath Murarka. We are considering the ongoing matters as closed. So he closed the matter, and your Lordship kindly sees page 96. There is a statement given by Vedika Securities Private Limited, where from
This is addressed to see Praveen Murarka.
Praveen Murarka, because that is his cause of action. That
is the applicant.
Applicant. That he wrote to Vedika Securities Private Limited, and Vedika Securities Private Limited once given a reply showing your Lordship the statement at page 97. He was shocked that where my father's shares have gone or vanished.
Page 90?
Page 96.
96, yes.
Yes. Page 96, your Lordship kindly sees DSQ Software Limited. His contention is suddenly he saw your Lordship in the year 2023 that all the shares have vanished and only 5,000 shares are left there. Kindly see your Lordship is pleading your Lordship in the application. Lordship, kindly take page internal page 4 at page 8, paragraph 8. Why I'm saying so, your Lordship, there's a reason. Then how your Lordship this is actually misleading the court. Paragraph 8, your Lordship kindly sees. Paragraph 7, I have shown your Lordship 2004 representation, and thereafter he suppressed your Lordship 2018. That your Lordship, the Vedika Securities have said that they have given in 2018 also. Now, at this junction, upon receiving a letter on or about 16 July 2023, petitioner was shocked to learn that on 10 July 2023, the statement of holding of Bhagirath shows only 3,000 DSQ shares in the name of the testator. All the other shares are shown in the demat account as on 5th September 2002, were fraudulently transferred, sold, or disposed of in course of the time to deprive the defendant, knowing fully well that some of the shares belonging to Bhagirath Murarka HUF, and it is not permissible in law to transfer, sold, dispose of any of the assets without taking a probate of a purported will dated 20th of October 2001. Moreover, your Lordship kindly also sees.
So this is the stand of the applicant.
This is a stand of the applicant by suppressing the entire civil suit, because your Lordship knows the testamentary jurisdiction, your Lordship is only required to see whether your Lordship the will is a genuine will or not, because the title of the shares cannot be decided here.
Yes, whether the acts of the executor during the pendency of the probate proceedings, that has to be gone into.
Exactly.
The probate court can go into the acts of
Exactly.
the acts of the executor.
Yes.
Acts of the executor during the pendency of the probate
if
proceedings.
the court sees your Lordship the executor
They has acted mala fide.
Certainly, your Lordship, the testamentary
that
court
is to be seen in this case.
Then in that case, your Lordship, the honorable testamentary court, your Lordship, can remove the executor, appoint administrative pendentality.
That means the probate court will not go into the title, but the acts and the conduct of the executor.
Exactly. Why I'm saying so? He is showing your Lordship 2004 and then 2023. 19 years, he was under the impression that this particular shares are there. That's the impression, your Lordship, they have given in the application. I have shown two things. 2008, the applicant filed a suit before the Alipur court for the declaration of those shares. 2013, I filed a written statement and described entirety. Has he come before the honorable court and showed that this is the written statement they have done in 2013? Kindly appoint the administrative pendentality right now. So therefore, 2004, 2008 suit filed, 2013 I filed the written statement. He is coming before the court in 2025 suppressing everything, and where the suit is still pending there. And what his contention is that the executors are acting fraudulently, transferring those particular shares. I have shown your Lordship during the lifetime of Shashi Murarka, the wife being the nominee, has your Lordship applied before Vedika for the transfer of those shares in her own account. She prepared a trust, and in that particular trust, by way of a gift deed, your Lordship, those shares have been transferred for the benefit of the grandsons. So if that is the case, your Lordship, what you are doing from 2013, I understand. When you have come before this honorable court, have you disclosed it? This is your duty. And you are suppressed it and not dealt with, your Lordship, when the learned advocate, your Lordship, argued the matter. Now, your Lordship kindly sees the Vedika also filed a written statement before the Alipur court. That has also been suppressed. Your Lordship, kindly take. Lordship, kindly take page 239.
That is volume 2.
Volume 2, Your Lordship, page 231. Okay.
Yes.
Now, Your Lordship, kindly sees page 239 is the written statement filed on behalf of the defendant number 9, who is Vedika Securities Private Limited, in the suit itself.
Yes.
Now, Lordship, kindly, Your Lordship, skip, Your Lordship, kindly take paragraph 8 onwards.
Yes.
Where there is an propositive averments there. The answering defendant is engaged in the business of stockbroking and depository services. The answering defendant is the duly registered under the Security Exchange Board of India as a stockbroker, being the member of the National Stock Exchange, and a depository participant, being the business partners with the Central Depository Systems and the National Security Depository Limited. One Bhagirath Murarka requested and or applied and or approached the defendant, the answering defendant, inter alia requesting to open an individual beneficiary account along with the answering defendant in the name on 27th of June 2000. And at the time of such application, the said Bhagirath Murarka was agreed to abide by and to be bound by the rules as enforced from time to time for such account. Pursuant to the request of said Bhagirath Murarka, the answering defendant opened an individual beneficiary account having account number such and such in the name of this said Bhagirath Murarka, and necessary agreement was made and or executed by and between the said Bhagirath Murarka and the answering defendant on 27th of June 2000. Copy of the agreement I have also annexed, Your Lordship, and in accordance with the terms with the rules, terms with regard to the nomination of the beneficiary's account, nomination can be made only by individuals holding beneficiary accounts. The said Bhagirath Murarka nominated his son Praveen Murarka in respect of account, but subsequently the said Bhagirath Murarka has changed nomination and the nominated his wife Shashi Murarka in respect of the said account. So initially it was Praveen Murarka, but Your Lordship, the testator himself changed from Praveen Murarka to Shashi Murarka, to the applicant, to the wife. The said Bhagirath Murarka died on 5th of September 2002, and by a letter dated 10 September 2002, the said Shashi Murarka, being the nominee of the said account, intimated that the answering defendant about the demise of Bhagirath Murarka, and also requested to transfer the shares lying in the said depository account in the said Bhagirath Murarka in her name. Pursuant to the request, the said Shashi Murarka, and after completing necessary formalities, the answering defendant transfer all the shares in the name of Shashi Murarka, save and except the share of one company which were already pledged by Bhagirath Murarka. So therefore, Your Lordship can understand that this particular letter cannot be a cause of action for filing an application for administrative pendentilite.
Anyway, you continue on the next day.
Yes, Your Lordship. Any day, Your Lordship, kindly grant.
Yes. Learned advocate representing the executor, petitioner, submits but could not conclude the submissions. Let this matter appear. আচ্ছা 12 তারিখ দেখুন তো দুটোর সময় কিছু আছে কিনা দুটো কি তিনটে আচ্ছা, ওকে, লেট দিস ম্যাটার অ্যাপিয়ার অন 12 বা 12 তারিখে দুটোর সময় আছে। যে 13 তারিখে দুটোর সময় থাকবে হয়তো। ওকে, 13/8/2025 at 2 p.m.
13th August.
At 2 p.m.
2 p.m. Yes.
এটা নিয়ে যেতে হবে।
না না যেটা ইয়ে করবো জজের ওদেরকে চেতান
Yes, what is this matter about?
My lord, this matter, your lordship remembers, there was there's a suit filed by my client. There are two applications that were.
Yes, analogously it was heard out.
Yes, my lord. My lord, my learned friend's application for dismissal of the suit for non-service of writ of summons.
Right.
And my lord, my application for extension. Your lordship has been kind enough, my lord, to extend the time to, my lord, put in the writ of summons on payment of cost. Now, my lord, today, my lord, I have the cost that is payable to them, 40,000, and the 10,000 rupee check for the legal, the High Court Legal Services Committee. Both I have got in compliance of your lordship's order. My lord, my learned friend can accept this. I'm handing over here and now, and this I will put to the. My lord, this I will put to your lordship's court officer, or will put it
No,
to,
no, no, no.
to
Straight
directly
before
to
the
them.
committee.
I can take this. However, your lordship, my instructions are that from the solicitor are that we have to proceed with appeal.
Yes.
So, lordship, I will naturally have to take it without prejudice to
That's his
the
option.
right to prefer an appeal.
That's his option.
Anyway, I have to record that, there is a compliance. I have
Yes.
to record that
Yes, there's a compliance, and my lord,
And
that
so,
will handle it.
not prejudice to our right to prefer.
না এটা হ্যাঁ সিবি করেছে
Yes.
and my lord second thing my lord
What is this GA2?
yes GA2 is my application for injunction and receiver. Now my lord ad interim order I could get an order of injunction against my learned friend
That
which
is continuing.
no my lord, that is was continuing. My lord kindly takes your lordship's last order in this regard where your lordship had my lord reserved this matter for judgment, the matter that my learned friend argued. That was on 15th of May, if I am not wrong, my lord. Kindly takes your lordship's last order of 15th of May. My lord, 15th of May 2025. I can give your lordship a copy from the my lord. It was said that the interim order granted earlier on GA2 2024 stands extended for a period of 3 weeks after vacation or until further orders, whichever is earlier. This is my lord. This is my lord's last order. So the interim order was till 3 weeks after vacation. My lord,
Anyway, that was on 15th of May.
15th of May, 3 weeks after the vacation. That is after summer vacation. So my lord, that would take us to, I believe, but summer vacation.
End of June. Yes.
End of
it
June.
expired.
My lord. So my lord, thereafter, my lord, since we were awaiting the order, my lord, we did not really, my lord, want to mention the matter. But today it has come up for final hearing after exchange of affidavits. But I am saying that, my lord, this order has to be continued till the disposal of the suit because my learned friend really did not, my lord, did not apply for vacating of this order.
Anyway, I shall hear out the matter and in the meantime extend the same also.
Yes, my lord, kindly does that, my lord. I am only, my lord, praying that ultimately that, my lord, apart from the order of injunction, my lord, I'll tell you, lordship, what has happened. These flats are mine. There's no dispute. They do not claim, my lord, any proprietary rights over the flats. They are, my lord, the association of flat owners. The real dispute is they say that my clients have not paid a huge amount of arrears of maintenance and other, my lord, outstandings. Now, my lord, I am saying that I have been prevented to even enter into these flats. And my lord, due to a long passage of time, these flats have deteriorated very much. I have annexed pictures also, your lordship will see. My lord, I am saying let a special officer go and figure out what is the condition. Because, my lord, ultimately the basic principle of law is that till the disposal of a suit, the subject matter of the suit has to be preserved. It is not their case that it is their property. They are saying it's my property. My lord, at least let a special officer go and see what is the condition, because I can't even enter into my own property. I am not saying let me.
Yes. What is your stand with regard to this?
Yes.
Your lordship,
Yes.
with my most humble submission is that this matter needs to be heard out.
Yes.
Fully,
Yes.
before any of these prayers can be appreciated.
No. Interim order is continuing.
Yes.
Certainly, lordship. That is first and foremost my submission, that your lordship should not at this moment of time accede to such a prayer. Your lordship, our stance is very simple. First and foremost, we have not prevented them from accessing their flats in any way. We have no claims of any proprietary rights over their flats. They have annexed a newspaper advertisement stating that we, the respondent association, are trying to create third-party rights in respect of the flats and the car parking spaces that are supposed to be the subject matter of the suit property. Your Lordship, we have written to the newspaper because we have never caused for such an advertisement to be published.
What is the interim order that is continuing? Let me see.
Continue,
Mere status
not
quo.
to sell, transfer, or my lord, possession.
Okay, now
Status quo as
regarding
regard-
your prevention,
My lord.
you are being prevented from entering that.
Yes, my lord, kindly see their letters.
Where,
They are-
which
I'll
paragraph?
show your lordship, my lord. Kindly give me a moment's time. What is third? What do you mean? The affidavit to the- होता है proof is given to the affidavit to the- No, I'm grateful to my learned friend, my lord. Lord, kindly see, my lord, page 156, volume 156, my lord.
Page 150, volume 2 doesn't.
Volume 2. I believe it's volume 2, page 156. Thank you. Thank
You can go ahead and
you.
take.
Kindly see 156. The last paragraph.
Yes.
As there is no effort being made by you to clear your outstanding dues, we further grant you time till 20th July 2020. Thereafter, in case dues are not cleared, we shall go ahead and take symbolic possession
No,
of your flat.
thereafter, how much dues have you paid till today?
They
Lord,
asking an incredible
the
9
incredible
crores.
amount 9 crores.
23 crores, no dues.
No, fine. I'm disputing that payable, but question is, can an association take over my flats or allow me not to enter into my flats?
Yes, they can take by due process of law.
Yes,
Where is the due process?
but
Can I indicate, Your Lordship?
they have to then ask for recovery proceedings.
These letters that are being referred to, Your Lordship, we have addressed this in our affidavit. These letters were issued unilaterally, Your Lordship, by the erstwhile president of the
Look at
association.
the letter
They do
here.
not represent the stance of the association anyway because the association does not have any.
They have
right to take
taken
any
possession. Then let them
But
return.
if at all, by way of legal proceedings.
Well, kindly see 161. Kindly see 161.
As mentioned.
Let them return possession to me. 161.
161, yes.
Last but three paragraph as mentioned in your letter. My lord has found that.
Yes.
Last from the bottom, as mentioned in your letter dated 2nd July 2020, we have taken symbolic possession of your flat on 21st July 2020.
That is 1, 2, 5, and 6 on the ground floor of
Building premises on ground floor of, my lord, it would be, my lord,
28 by 1.
Yes.
28.
28 by
Ganga Jamuna.
Yes.
On the top and
Your
right,
instruction is you have not taken any symbolic possession.
We have not taken any symbolic possession. These letters, if your lordship sees, Mr. Abhay Chaudhary, since deceased, has signed these letters. However, there's no stamp of the association on these letters. These letters. were
In your
shown-
affidavit, you have stated these are all false letters, forged letters.
Yes, your lordship. Paragraph 21 of my affidavit in opposition. I've
কার
stated
তালা
this.
আছে ওখানে? কার তালা?
আমাকে তো ঢুকতেই দিচ্ছে না।
There are padlocks on top of it.
No,
He
Your
says my association, my
Yes, record an order.
president does not. Let the special officer go and see who is in possession.
An order.
Your lordship.
Learned
there's no-
advocate
Let the special
for
officer go
the
and see who is in
plaintiff
possession.
and learned advocate for the defendant are present. Today is fixed for hearing of this application GA2 of 2024, which is for grant of injunction and appointment of receiver. As the affidavits of these applications are complete, the matter can be heard on any particular day and concluded. Mr. Ghosh, learned advocate representing the plaintiff, submits that his client is not being permitted to enter into the suit property
My lord.
and the property is deteriorated. Such submission is disputed by learned advocate representing the defendant. It is also submitted by learned advocate for the plaintiff that by letter dated 6th August 2020, Ganga Jamuna Flat Owners Association has informed the plaintiff that they will take symbolic possession of the suit premises. It is also disputed by the learned advocate for the defendant. In the facts and circumstances, prior to taking up this application for final disposal, it is necessary to appoint a special officer to ascertain as to whether the plaintiff is being permitted to enter into the suit property or not. Secondly, in whose possession
My lord,
the
so
suit property is now lying. And thirdly, the present condition of the suit property be also inquired into and recorded by taking and necessary photographs be taken.
My lord.
Your Lordship, may I kindly
Yes,
indicate
yes,
such an order,
yes,
such an order with such an effect,
yes.
Your Lordship, until the hearing of
No, this
application is
this
No,
concluded,
no, yes, yes, yes.
there is no
Yeah, these all. No, no,
be
so
ready.
this order is
Ready.
issued as a stopgap measure and
Yes,
it is without prejudice.
My lord.
As a stopgap measure and it is without prejudice to the rights of the parties.
And prayer
But
B is there.
dash, appointed, fix 27/8/2025 for report of the learned special officer. Learned special officer shall conduct the inquiry upon notice to both the parties and their learned advocates.
So deep. Your Lordship.
Let a copy of this application be served upon the learned special officer.
My lord. Well, the interim order which is
The interim order granted earlier shall continue for a period of 6 weeks or till further orders, whichever is earlier.
so deep.
Great. (27/8). Yes, Mr. Paul.
I'm appearing on behalf of the defendant caveat.
Well, I appear, it's my application for grant of probate. Well, the evidence is complete, it's only fixed for arguments. We have to start de novo. Well, the last
Only
witness
the
of-
arguments.
Yes. The last witness was, in the box was, the defendant's witness. So,
For the defendant.
Yes.
So you have to start first.
It has come after a long time.
So are you ready?
No.
I'm fixing it on a particular date. Very well.
So because it's a 2001 matter, it has to
It
be
has to be, my lord,
expedited.
Yes, my lord.
Yes.
Kindly, my lord.
After 2 weeks and
Yes, record an order.
Weekend
Learned advocates for the parties are present. The matter is ready for arguments. On the prayer of learned advocates, let this matter appear on. Achha,
any time after, my lord, 17th of August, my lord.
20 তারিখে দেখুন তো দুটোর সময় কোনো ম্যাটার আছে? 2 বা 3টের সময়? দুটোর সময়। আচ্ছা, 21 তারিখে? আচ্ছা, ঠিক আছে, আমি 21 তারিখে। Yes, I'm keeping it on 21st of August at 2 p.m.
I'm so grateful, my lord.
2 p.m. at the top. At 2 p.m.
I'm grateful. 21st. 21st.
Milord, item number 21 is my general application, Milord, for revocation of a grant of probate. Item number 22, Milord, Mr.
A1.
Yes, Mr. Mitro Lanet, Senior Advocate's application, Milord, for intervention, where affidavits, Milord, have been exchanged. Your Lordship can take up that matter. And Milord, item number 23 is Mr. Madura's application, Milord, representing, Milord, another intervenor. Where Milord,
Let us take up GA2 first.
Yes, it is scheduled for that. Milord, may I file my affidavit in opposition to GA2?
GA3, my lord.
Already served.
Despite 2 opportunities, has still did not find his opportunity.
It did. No, the GA3.
GA3.
GA3, the reply has been, we have received the
served
reply.
on me because
that is not
both are in the same boat.
Yes. GA2 and GA3, my lord, are by and large similar. Prayers are similar. Parties are different. So
That is
GA2 and
fine.
GA3, my lord, I
Well, let me consider GA2 first.
Yes.
Well, GA3, my lord, will kindly treat it as unopposed because he's taken 2 opportunities. Last time also he said perhaps he does not want to file an opposition. Then at the last minute he changed his mind and said he wants to.
No, the
point of
Milord,
law
GA2,
involved.
Milord,
GA2
we kindly
and
take it up.
GA3 are the same, my lord.
Milord, I-
Now, maybe yes, the parties are different.
What are the grounds for intervention?
Now I'll tell you, Lordship. Lordship will take up my application once. I may not be able to complete today, but I'll place the facts. Now, my lord, GA, Lordship will kindly come to page 35 of the application because facts are quite complicated, my lord. Let's place one by one. This is a family tree. Probate হয়েছে বলবে। 7 কার probate বলো? সেখানে কমতি চামারিয়া। My lord, this is the family tree of probate কবে হয়েছে? 97. Probate was 1996. Of আওয়াজ হচ্ছিল না। Of late Rai Bahadur Motilal Chamaria. He died leaving behind two wives. One is Gomti Shethani Chamaria, the other one is Sheila Devi Chamaria. There were two ladies. Now today we are in the testamentary proceeding of Gomti Devi Chamaria. Now Gomti Devi Chamaria biologically had one daughter which is Shavitri. So she will mark in the family tree. Biologically, she had one daughter, which is Shavitri. Shavitri and the second wife, Sheila, is having a son, Umesh.
Shavitri predeceased.
Yes.
The testee.
Yes, I will just come to this. So Shavitri predeceased Gomti. Shavitri had children, which is Bijoy, Bimal, Uma, Tuni. Now, Tuni died as in the childhood as a spinster. Now, so far Uma is concerned, but Uma is not contesting in any of the proceeding. So we are left with two sons, which is Binay and Bimal of Shavitri. Here, which is one important thing is that she will now come to there is another entry in the extreme left-hand side, Bijoy Chamaria. Son of Gomti. Now, Lordship is recorded over there. This is an adopted son by Gomti. So, Bijay is not the biological son of Gomti. Bijay is an adopted son of Gomti. And Bijay happens to be the biological son of Shavitri. The mother adopted daughter's son. Bijoy and Binay, they were twins. Bijay and Binay. So
no, Bijay is the adopted son. Adopted son of this Gomti.
Gomti, yes. But the biological mother.
Biological, yes.
Biological mother is Shavitri.
Okay.
That's how I'm on. Biological mother is Shavitri. And Bijay and Binay are twins. That is unimportant for here. But biological mother is Shavitri. Now Bijay is adopted. Now kindly also note, my lord, Shavitri got married. It was Chamaria before the marriage. After marriage, she became Dhandaniya, the surname of her husband. And the other sons of Shavitri continued with the surname of Dhandaniya till their death. Today, and then when Bijay got adopted to the Chamaria family by her maternal grandmother, Bijay took over that surname of Chamaria till his death, because Bijay died in the year 2006. Thus, you will see that diseased on 14th of December 2006.
But this Shavitri died prior to her mother.
Yes, that might be died prior to her mother. Now, who am I? I am Umesh. I am the son of the second wife.
Yes.
Now, who is the GA1? I am the petitioner in GA2 is Umesh. GA1 is an application for revocation of grant of probate of the will of
This Gomti.
Gomti. Filed by whom? Filed by Amit. Lordship will now say to Amit is Shavitri's son is Bimal. Bimal's son is Amit. So this is the position in the family.
Who was the executor?
Yes, I'll just because this I'll just come to all these things. So I am Umesh here. The applicant, the petitioner in GA1 is Amit. Amit has now made an application for revocation of the grant in the will of Gomti. Gomti left behind a will. This will is at page 31. The typed copy is 31A, my lord. Gomti died in 1994. The probate was filed immediately thereafter. This is the will of Gomti. This is the last 31A, the type copy. Convenient. This is the last will and testament of me, Shethani Gomti Devi Chamaria, widow of late Rai Bahadur Motilal Chamaria, at present residing at 55 Muktaram Babu Street. But will kindly mark the address also because this becomes of some importance later. PS Jorashako, Calcutta 7,07,000 in the state of West Bengal. I hereby revoke all my wills and codicil and other testamentary dispositions of every kind hereto and declare last will. I declare that I am a citizen of India and a Hindu. I appoint, now will come, my son, Vijay Kumar Chamaria, aged about 53 years, by faith Hindu, of 68 Cotton Street, Badobazar, as the sole executor of my last will and testament in case the said Vijay Chamaria dies in my lifetime or he refuses or unable to act as an executor, then type copy. Then in such event, well, there is a handwritten copy. Then in such event, I appoint my wife, his wife, Aarti Chamaria, and his son, Master Anirudh Chamaria, to be the joint executor of this, my last will and testament. So he appoints his son, Vijay, which I showed in the family tree, the adopted son, Vijay as the executor. In the event of refusal or predeceasement, he appoints Aarti, which is the daughter-in-law, wife of Vijay, as the and Vijay's son, Anirudh. But that situation did not happen because Vijay acted as an executor. I will continue, father. I give, devise and bequeath my estate, now known as...
Which paragraph you are reading?
My lord, is at page 31.
31A.
31A, the last, then 32. There should be a type copy, my lord. I think only page 31 is typed.
32.
Yes. Yes, shall refuse or enable to act as an executor. Then the first para of page 32. Then in such event, I appoint his wife, Aarti Chamaria, and his son, Master Anirudh Chamaria, to be the joint executor of my last will and testament, and it will be effective after my death. So the first executor is his son, Vijay. In the event Vijay predeceases or refuses to act, then Vijay's son or Vijay's wife. I continue, father. I give, devise, bequeath my estate, now known as Radha Bhavan Estate, situated and lying at Mussoorie, district Dehradun in the state of Uttar Pradesh, which was purchased by me on the 20th of April 1929, then known as Bellevue, together with movables and immovables of whatever kind and nature, herein referred to as my said properties, unto to my son Vijay Kumar Chamaria, to be held by him absolutely and forever. I direct that such sum shall be spent for my shraddh and funeral ceremonies, maybe fitting my portion of my society, subject to the aforesaid payments and also subject to the payments of the debts and liabilities out of my estate to the executor named herein, may apply for the grant of probate before the appropriate court of law, in witness whereof signed. So the executor is his son, the beneficiary is his son. Son is Vijay Kumar Chamaria. Now, Lordship will once again will kindly go back to the family tree. So this Vijay, and then Vijay's son is Anirudh, which is mentioned in the will. Now Vijay died in 2006. Now what did Vijay do? Vijay applied before this honorable court with this will. Page 27. Now Vijay applied before this honorable court and obtained probate of this will. So the property left behind by his mother, Gomti, under the will got bequeathed to his son, Vijay.
No,
Now,
during pendency of the probate proceedings, Vijay Chamaria died.
No. Probate was granted in...
No, pendency of this, I think, after the death of this Gomti Chamaria.
Gomti died in 1994.
Yes.
Probate was granted in 1996.
Very well. So after the death of...
Vijay died in 2006.
Yes.
After
So
10 years.
That means prior. That means after the probate was granted.
Yes. After 10 years. Maybe the dates are a bit confusing. That's why I'm going very slow. I know even for me it was very confusing. So in 1994, Gomti died. Probate was applied. Probate was granted in 1996. Vijay died in 2006. Now, in the proceeding, because we don't have copies of everything with me, my lord. Now, Lordship will kindly see page 37. Page 37. Now, first we'll, page 37. Once we are already in page 37, is important. Page 37 is this is in connection with a caveat. Now, Lordship I will digress from here. This Lordship will see in the goods of Motilal Chamaria.
Yes.
This becomes the father. Now, why these are annexed here? The dispute has now cropped in whether Vijay was adopted by Gomti. Because today, when Amit is coming over here, now the question which is being raised, whether Vijay was adopted, because this application was filed after 28 years of grant of probate. This revocation. Now, I have to show that the parties, we said that there has been ceremonies, this adoption has taken place by the rituals of the prevalent at that point of time in the said community. Why I bring on page 37 is, page 37 was a different testamentary proceeding in connection with Motilal Chamaria. Here, the husband of Gomti. Here, my lord. Now, Lordship will see this is an affidavit. All proceedings of this honorable court is saying Vijay Kumar Chamaria, aged 22 years, son of late Rai Bahadur Motilal Chamaria. He filed this petition because there was some dispute with regard to the will of Motilal, and it continues that I have read a copy of the petition of the probate by Khemka, Sarangi and Saxeria, because the others have filed. So in this affidavit also, which is filed as far back in 1958, this is an affidavit affirmed in 5th of January 1958. There also Vijay Chamaria is claiming himself to be the son of late Rai Bahadur Motilal Chamaria. And he files this affidavit for contesting that will. I am only on the point whether the adoption took place, how the parties have acted upon after this adoption. Because I must admit to this, there is no adoption deed. This I know Mr. Banerjee has made a huge paragraph in the opposition with regard to the adoption deed and the Hindu Adoption Act and all. So I am saying this. So there is no adoption deed, I am making this. So how the parties have acted upon, how the parties have altered their position. So this affidavit is filed by Bijay in the goods of Motilal, claiming himself to be the son of Rai Bahadur. And its further paragraphs are not important, my lord, because it's the other stands are taken. Next. Now, my lord, identically, the mother, lordship will see, Savitri also filed an affidavit in the probate proceeding of Motilal Chamaria. It is at page 44.
This is affidavit in support of caveat.
So yes, yes.
Okay, the other is?
Other is similar. Other is similar.
Yes.
Page 44 is also in the goods of Motilal Chamaria,
Yes.
where also Savitri claims to be the daughter of Motilal, which he has rightly said, but he has never opposed the position of this affidavit of Bijay, while Bijay is claiming to be the son of Rai Bahadur.
This is also affidavit in
Support of
the
caveat. Support of caveat. But Savitri's stand here is page.
Savitri is not an affidavit.
Savitri, I'll read then, Mala Savitri. Yes, Savitri is also. Yes, is an affidavit. You've seen paragraph 2. On or about December 2, a special citation dated November has been issued by the Honorable Court and served on me. So he's replying to the citation must be. I have read over and explained by me the special citation and the affidavit verified by Bajrang Khemka. And I think I have understood and purport. Then the allegations made therein. So he is giving the opposition to the probate application must be. In that way it's written, Malad, own paragraph. Now after he has written, I am say that about the time of the purported execution of the alleged will, the deceased was not in sound mind and understanding. So this is affidavit in support of caveat in the form of an affidavit, obviously. Now we'll kindly come to page 40. Paragraph 12. Paragraph 12. Yes. Paragraph 12, where she asserts that Bijay is the son. I'm only on that portion in the affidavit. Paragraph 12. With reference to paragraph 8 of the petition, I say that I am an heir and legal representative of the said deceased, and I deny the allegation. I further say that Bijay Shankar Chamriya is the adopted son of the said deceased. This position is admitted by the grandmother of the present petitioner in GA1, who is the daughter of Rai Bahadur. So this position is admitted by your grandmother. Now, he admits this. Today, so these are on the issue of whether the adoption at all took place or not. So these are the two applications. Now, Lordship will kindly come to page 36, which is the death certificate of Bijay Chamaria. Now, I have shown to the court that at the time of birth, this Bijay was born in the family of Dandaniya. And then he was adopted by his maternal grandmother and he became Chamaria. Page 36 is the death certificate of Bijay Chamaria, which records first Bijay Chamaria. It is not very clear,
Yes.
It's Vijay Chamaria, but these are admitted documents, not in dispute. Son of late Motilal Chamaria. Even the death certificate records, and the date of death is in 14th of December 2006. So these positions are admitted. It is not the case that a death certificate is false or something. So it is Vijay Chamaria, son of late Motilal Chamaria. So till the death, Bijay Chamaria continued to be the continued with the Chamaria surname and he died.
Continued to represent himself
As the family of
son of Motilal Chamaria.
my lord, as son of Motilal Chamaria. Now, if I am permitted to say, up to this it was okay. Now
although the claim is adoption after
after the death,
Motilal Chamaria, although his wife took adoption.
Your grandmother never opposed. I will show documents where the petitioner in GA1 himself acted upon in terms of the adoption. I had indicated, my lord, the property at 55 Muhtaram Babu Street, which is mentioned in the will. But she will kindly come back to the will. She will kindly come back to the will, page 31. Page 31 is 31A is the property where Gomti used to reside.
Yes.
This is 55 Muhtaram Babu Street. The first para refers where Gomti used to reside. Now later, much later, parties have sold this property, 55 Muhtaram Babu Street. I have the certified copy of the deed with me. I have annexed. Where Amit, who is the petitioner in GA1, is himself a signatory. His sisters are signatories, where they admit of this adoption. I'll come to that later. Now, Lordship will kindly come back to the family tree. Up to this stage, Mala, the situations were perfect. Now the question arises, what was the necessity for filing a revocation application by Amit, page 35, let's see with the family tree, after 28 years of the grant? Why? And how I come in? That both I have to answer. Now, Lordship will see after this, Bijay got the probate in the year 1996 of his mother. Then Bijay died in 2006. Properties leaving behind Bijay's wife is Aarti and Anirudh. Thereafter,
is there and another is
Bijay's wife is Aarti. Bijay's wife is Aarti. Aarti was there when Bijay died, and then Anirudh.
Sometime in 2016.
Lord, she will kindly mark that Aarti died in 2016.
It is reflected here anywhere?
No, it is not there. Maybe in my pleading.
Anyway, that is
Bijay's wife.
Bijay's wife.
The pleading issue.
And his son is Anirudh.
Anirudh. Yes, in paragraph 3 of my petition, I have mentioned Aarti died in December 2016. Then, on the death of Aarti, Bijay's property, which is basically the Mussoorie property and other properties mentioned in the will of Gomti, devolved upon Anirudh, the only son. Aarti is gone in 2016. The property devolved upon Anirudh in 2022. Anirudh died in January 2020. So we come to more nearer dates. Now, Anirudh, the family tree will make it clear. Anirudh died in January 2020 as a bachelor. He dies as a bachelor.
Yes.
Here the dispute crops in. He dies as a bachelor. His mother predeceased him, Aarti. Anirudh died as a bachelor. Now, when Anirudh died as a bachelor,
Anirudh, okay, he is the only son.
Only son. He's the only son. Anirudh died as a bachelor. So the Mussoorie, only child. Yes. The Mussoorie property was with Gomti. It came to Bijay. It devolved upon Aarti and then now to Anirudh. Now, Anirudh, when died as a bachelor, we find Anirudh left behind what we understand from a will. A will, rather I'll say Anirudh left behind two wills. Anirudh left behind two wills. One in favor of Mr. Banerjee's client and one in favor of Mr. Medora's client. He left behind two wills. Now, so far as the Mr. Medora's will is concerned, here the situation is getting a bit murky. He left behind two wills. Now, so far Mr. Medora's will is concerned, as far I am aware, I am Umesh. As far I am aware, this will till date has not been put for probate. Subject to correction by Mr. Medora, as far I know, not been put for probate. Now, so far the will in favor of Mr. Banerjee's client is Amit. He has filed this will for probate before this honorable court, which is the obviously ওখানে ছিল না the গ্যাপটা ফিল করতে হবে না তো sorry madam. So now Amit, who is the Mr. Banerjee's client, Amit is a beneficiary under the purport, and I say a purported will or alleged will of Anirudh, who has filed a probate application for grant of probate before this honorable court, which is marked as
Amit acting on the will of Anirudh.
Amit, yes, as an executor, beneficiary, whatever, as an executor
to a particular will
of Anirudh.
Yes, and there is another will.
Another will of Anirudh in favor of Mr. Medora's client.
That is
outside the family.
Okay.
Some Khanna.
Which one is later? Subsequent will.
I'm not aware of the date. Oh, Mr. Banerjee's client will. I say both are forged, both are manufactured, both have been brought into existence after the death of Anirudh. But so far, Mr. Medora's will is concerned, till it is not been filed for probate, so there is no question of objecting it. So far, the will of Anirudh in favor of Amit is concerned, he has filed a probate application being PLA number 88 of 2021 before this honorable court.
PLA 88.
88. Page 12. Now, this is page 12. The application filed by, in the goods of Anirudh, filed by Amit. Page 12. Now, this is the application for grant of probate in respect of the will. The will is also next matter at page 25, which is filed by Amit today before this honorable court in respect of the estate left behind by Anirudh.
Yes.
Now, in this proceeding, I appear. In this proceeding, my lord, I appear. I am Umesh. Now, Lordship can come back to the family tree. I am Umesh. I appear in PLA 88 and say and filed caveat as well as affidavit in support of caveat. With the leave of the court of Justice Saraf, my lord, I have filed affidavit, caveat as well as affidavit in support of caveat.
With regard to the will of this
Anirudh. With regard to the will of Anirudh.
That is bequeathing the property to
Amit.
Yes.
Bequeathing the property to Amit. So I am Umesh. I have filed a caveat.
Umesh means where? Okay.
Umesh is the.
That is Sheila Devi.
Sheila's son.
So you have filed a caveat as well as
affidavit in support of caveat.
Yes.
I say I have a caveatable interest in the estate of Anirudh, on the strength of which I have filed the caveat. Now there are proceedings pending in the before the coordinate bench with regard to the estate, the probate application of Anirudh, There are applications for injunction. Injunction has been granted. There is also an application for revocation of my caveat. Those are pending. So till date, my caveat stands, and I am contesting the grant of the will of Anirudh. Now what happens, my lord?
So when was the probate granted of Aniruddha's will?
No, it's not granted, it's pending.
Pending. So it's
Pending.
contested matter.
It's a contested matter. 2021. He died in 2020, and yes, it's Aniruddha in Bengali terms. We did it.
Anirudh.
Anirudh in Hindi. So it's PLA 80 to 2021. It's pending. So I have to contest that. Revocation. So that's pending. My caveat is there. I claim I have a caveatable interest in the estate of Anirudh. Whether I succeed or I don't succeed is subject matter of the different proceeding. I'm not. Now, after this was filed in the year 2021, this probate application, Amit now comes to attacks the will of Gomti in 2020. কবে ফাইল করলো ওটা? In 2024. PL নাম্বারটা 1টা বলো কোন সালে? 134 GA 1 of 2024. So after filing and after my caveat is there, Amit now comes in and files GA 1 in the estate of Gomti after 2 years of filing the application in the goods of Anirudh. Now what happens? The property is the Musori property, which is subject matter of the Gomti's will. It has devolved upon Vijay. It has gone up to Anirudh. Now Anirudh has now given it to, purportedly under the will, to Amit. In the affidavit of asset of Anirudh, this property is mentioned, a Radha Bhavan Musori. Now, while propounding the will of Anirudh in a coordinate proceeding, before coordinate bench, now Amit comes in and files GA1 challenging the grant in favor of Vijay.
Now the question is, you see, if Vijay is not there, where will Anirudh come? If Vijay has no right, the source of Anirudh right is Vijay.
Yes.
If Vijay goes, Anirudh also
goes. Then what happens? Then what's the idea of filing GA1? The idea of filing GA1 is
Anirudh has bequeathed to Amit.
Anirudh has allegedly bequeathed to Amit. Now, Lordship is perfectly right.
Yes, if Vijay goes,
if Anirudh goes, sorry, if Vijay goes, Anirudh also goes.
If Vijay's, that is Gomti's will is challenged.
Yes.
So from Gomti comes Vijay. So if Vijay goes, where will be Anirudh?
No one.
Entire thing goes.
Entire thing goes. Then the question which begs an answer: why did Amit file this application after 28 years seeking revocation of the grant in favor of Vijay? That has to be ascertained, my lord.
Yes.
Because my lord is absolutely in the right. If Vijay goes, Anirudh goes. Now Amit feels.
And if there is no Anirudh, so where will be the scope of Amit?
No, according to Amit, he need not. Then he goes back that Gomti did not die intestate. That is the trick, my lord. Lord, you will kindly appreciate.
Yes.
Amit will say Gomti died intestate because the will is challenged. He is asking for revocation.
Yes.
So the moment Gomti dies intestate, the case will be, and he's at the same breath, he's challenging the adoption. So he is saying Vijay is no more the son of Gomti. Gomti died intestate. So the property left behind by Gomti will devolve on Savitri. Will devolve on Savitri and then goes down to Amit in an intestate succession. That's the object of, that's the idea of challenging it, but I understood. এটা তুমি বলো। So he is not confident of his probate proceeding, which is PL 88 in the goods of Anirudh. So he is opening a alternative, a plan B. He now says, if I challenge the authority of Bijay, then Bijay is out. Today, Lordship will appreciate who will come to oppose this GA1. This is very important. He is asking for revocation of the grant in favor of Bijay. I ask the question to myself, who will come to oppose?
And what is your application for? That is,
Yes, mine is GA2.
yes.
Mine is GA2.
This is GA2.
Yes.
Okay.
Mine is GA2. I say, okay, liberty be granted to me, the Umesh Chamaria, the prayers in my master summon, to intervene in the present proceeding. Liberty be granted to the intervener to contest GA1. Because I said just now, who will contest GA1? The hearing is kept in abeyance with C is and a copy of GA1 be served on me. So these are my prayers. Now, if Lordship's papers are here,
One that is revocation.
Revocation.
In favor of Bijay.
The grant was in favor of Bijay.
So that although this your client is not a successor, direct successor.
That I will establish, my lord. Whether, because I have filed caveat in the goods of Anirudh. If I have a caveatable interest in the goods of Anirudh,
yes,
this automatically dates back to Anirudh's father. I will show on the next day, because I am, Lordship will kindly appreciate why I say, I am the brother of Bijay in the family tree. Lordship will see. Rai Bahadur left behind two wives. One is Gomti, one is Sheila. Bijay is Gomti's son. Bijay is Gomti's son. I am Sheila's son.
Okay, very well.
So I am half brother.
Half blooded.
Yes, I am half brother of Bijay. If I can maintain a caveatable interest in the goods of Anirudh, now I will show on the
Suppose if Bijay Chamaria dies intestate, it will fall upon whom? His son and wife? Yes. Assuming.
Yes, yes.
that
We need
Bijay
to go.
Chamaria dies intestate.
Malad will
It
kindly.
go to-
Will kindly. I missed the question.
So suppose Bijay Chamaria dies intestate. So
Bijay died intestate.
Bijay Chamaria.
Bijay died intestate.
Okay. So
Bijay anyway died. The property automatically came under Arti and Anirudh.
So after it has come to Arthi and Anirudh, where is your position? That is the thing.
Now after Anirudh,
there,
what
this-
happens?
These persons come in the picture.
Umesh.
Arthi and Anirudh.
Arti and then Arti died.
So you see, from Bijay, apart from Anirudh and this Arti, it will go to nobody. Apart
No.
from
Anirudh. Then Arti is Arti has died.
Anirudh remains.
Anirudh died.
Yes, very well. Anirudh died. Arti died, leaving behind Anirudh. Okay.
Anirudh died.
Yes.
Then the question is, then where the property will go now? Who are intestate successors or intestate heirs?
In case of male.
Yes,
Yeah.
I will come to that.
Male heir.
In case of a will, you can change the line of succession.
No, in case of a male heir, who is
Yes.
the
Yes, in case of
successor?
14, yes, 8, sorry. Yeah. In case of male, a Hindu male. Hindu male. In a situation where Anirudh would have died intestate, because my case is, because I in the caveat affidavit in support of caveat of Anirudh, I have challenged the will of Anirudh, which is propounded by Amit now. So now I have to establish, on the next day I'll go that what is my right today to oppose this revocation of Bijay. That's the problem. We have a 100 crore property.
No, at present you are confining yourself, that
Yes.
with regard to caveatable interest, that means you have filed affidavit in support of Anirudh Chamaria.
Yes.
Okay, that will.
Yes.
And
I have filed my affidavit in support of caveat is there. So I'm contesting so I claim I have an interest in the estate of Anirudh.
and your revocation application is with regard to the probate of Vijay Chamaria.
Estate of Gomti. Estate of Gomti.
Yes.
Estate of Gomti.
Okay, that means.
So now what happens?
Revocation of the grant of probate of the will of Gomti.
Yes. And they also challenge this adoption. Because they say the adoption never took place, so the property entire property will go to Savitri. So Bijay will not get anything because Bijay's line has come to an end today. Bijay has died, Anirudh has died. So no more the Bijay's line, it goes to Savitri's line. The main issue is, my lord, whether Vijay was adopted or not. If Vijay is adopted, then I am the half brother of Vijay.
Yes.
Amit comes below me. Even if I go by schedule or by agnet, I'll show on the next day, my lord. If Vijay and Umesh is in the same footing, then I am the half brother of Vijay. And the Succession Act, there is no distinction between a half brother and a full brother. Is a distinction in uterine, but there is no distinction in half brother or full brother in the Hindu Succession Act.
Yes.
If it is a uterine, then is a difference, but not in whether the mother is common or father is common, whatever. So if Vijay is the son of Gomti, then I am the half brother. So on the next day, my lord, we'll kindly keep it on Monday or tomorrow, whatever. I'll just show then how I have a caveatable interest and why, if this revocation is allowed, then how I am prejudiced. Today I have to show this much. If the revocation is allowed,
if GA3 is
no,
GA1 is allowed.
GA1 is allowed, I am prejudiced. That is the only. Now, after these facts, I have to show to the court on the next day.
Revocation of the grant of this.
Of Gomti. If that is allowed, I am prejudiced.
GA3 also have to do the same thing. If the grant of revocation is allowed, how will I suffer?
How will I suffer? In these facts.
I am Neeraj Khanna, who has a will in his favor from Anirudh. As Mr. Mitra has pointed out, there are two wills of Anirudh. One in favor of Mr. Banerjee and Mr. Mukherjee's client, Amit Dandania, and one in favor of my client, Mr. Neeraj Khanna. If this will of Gomti is revoked, then Anirudh's right over this Mussoorie property goes away, which is why I am prejudiced.
Yes.
Which is why I have a right to oppose this revocation.
He is the beneficiary under a will. I claim a beneficiary under intestate succession.
Both are on different footings, so that I'm opposing both that.
Yes. So I have to show on the next day that how I am prejudiced if GA1 is allowed. And then who will oppose GA1? This is a question that begs an answer, my lord.
That will have to be seen as per law.
My application.
Yes.
Mr. Mitra's client at all has a right. That has
Yes. We will.
My application can be treated as unopposed because he's chosen not to file any opposition.
Yes.
So my application can be unopposed.
3 bar extend.
Well, we are seeking extension of time to file the opposition.
Okay.
How many times will he take extension of time? to file?
GA2 is been there 2025.
Mr. Medora does not oppose.
Learned advocates for the parties are present. Heard learned advocate for the applicant in GA2 of 2025. As hearing could not be concluded, let this matter appear on 14th দেখুন তো কটার সময় আছে, তিনটের সময় আছে কি?
14th problem.
হ্যাঁ 14th
And some problem on 14th, my lord. Some other matter is already fixed on 14th.
কটার সময় ফিক্সড আছে?
No, in the after 2 PM, দুটোর পরে আছে?
14, 13 any রাখুন না।
3 p.m. আর 2 p.m. আছে 4 p.m. আছে
14th এটা তো 3:30 হবে।
Okay, let it be at 2 p.m.
Yes.
14th at 2 p.m.
Grateful.
কটা হয়েছে 14 তারিখে 2 p.m. এ
এটা একটু সময় লাগবে।
4টে রয়েছে 2 p.m. এ তাহলে 3টের সময়
Can it be kept on 11th?
এই 11 তারিখে কিরকম আছে দেখুন
আমি রেডি হতে হবে আমার।
3টের সময়
না 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 নট অন 11 মানে আমি বলছি তো
না তাহলে
না 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 আমি আজ সোমবার রেডি হতে পারবো না 13th
এ
যবে খুশি রাখুন আমার পরে
18th.
let it be expedited why he
yes
14th is fine, madam.
14th
because it will not conclude
True.
another day may be required
yes I may not
But I will have to submit.
আচ্ছা
14 3 p.m.
আচ্ছা
2 p.m.
আচ্ছা
না, দশ সাহেব-
কখন বললেন 11th এ কটার সময়
তাহলে হবে।
আচ্ছা 11th at 3 p.m. 11th কি দুটোর সময় আছে নাকি
3 p.m. is fine.
11 3 p.m.
উইটনেস অ্যাকশন রয়েছে 11 3 p.m.
কি যাবে না রেখে
11th তুমি না বলছো
11th তো রেডি হতে হবে আমাকে
সেই যে 14 3 p.m.
আচ্ছা যাক
below
ছেড়ে দিন
is fine.
এই 18th এ দেখুন তো 2 p.m. করা যায় কিনা
নাথুলা এখানেই আছে তো
18th
নাথুলালটা আছে এখানেই আছে সেটা 14th এই রেখে দিয়েছে মানে কি বিট 14 3 p.m.
কোর্ট অফিসার বলছে 3টে 2 p.m.
আমাদের 3 p.m.
কিছু 3 p.m. হবে উইল ডু ইট ফর হাফ অ্যান আওয়ার 3:30
এটা উলসুট একটা উইটনেস অ্যাকশন থাক 18th এ
হ্যাঁ
18th থাক
14th let it be at
3 p.m.
14th at 3 14th at 3 p.m.
Will only for the GA3 I have not filed my opposition. Your lordship will permit this.
the acha
Was this kind of
acha next করুন GA1 of 2024 let this matter appear along with GA2 of 2025 on 14/8/2025 এরপরে আসুন GA3 of 2025 let this matter appear along with GA2 of 2025 on 14/8/2025 the affidavits must be exchanged in the meantime
Will come as mark 3 p.m.
3 p.m. 3 p.m. টা লিখে রেখো তুমি ভুলে যাবে না
GA3 তে affidavits must be exchanged in the meantime আর 14/8/2025 at 3 p.m. করে দিয়েছেন তো
লিখে রাখো ভাই
না না সব 3 p.m. সবগুলো
হ্যাঁ আচ্ছা একসঙ্গেই তিনটা 3 অবলাইজ ডিপলি
ইন্ডিয়া ফিক্স ম্যাটার আছে না কল করে দিন
I think about 24 to call time হয়ে যাবে time হয়ে যাবে defendant's witness my lord I have the defendant witness my lord he is not able to come today for some family bereavement my lord
yes
DW2 my lord
Your Lordship, I appear on behalf of the plaintiff. DW1.
no DW1 is completed so this is the second notice I will bring DW2 so my lord
so will he be able to come
my lord, if the family bereavement is this month, next month, any day next month. Any
otherwise I can do one thing
this month we have some problem.
আচ্ছা রেকর্ড করুন তো অর্ডার
No, cross exam
learned advocate for the parties are present
for the day.
it is Mr. Banerjee learned advocate for the
Your
defense
Lordship,
Yeah.
DW1 का cross examination is not concluded. Take out the-
Completed.
I have the deposition. Take out where
no is it DW1 or DW2
DW1, Your Lordship. DW1 has not been cross examined.
I have ordered for it.
No,
So you want
conclude.
to go?
Yeah, we want to continue. Your Lordship,
If they want to continue, then I'll bring DW1 myself.
acha learned advocates for the parties are present as cross examination of DW1 is not complete let the matter be fixed for
after 15 days any
cross
time.
examination of DW1 on
Any short
21
date maybe.
8/2025 at 3 p.m.
Grateful, Your Lordship.
21/8 is because these are families, my lord. The bereavement is also their brother.
Your Lordship, it's a
September
suit
first
pending
week,
since 2012, Your Lordship.
So much
Who's
date has
bereaved?
gone, my lord. September first week,
Your Lordship, kindly let it be on 21st, Your Lordship.
Will not be able to come, there is no use of keeping it.
So when did the bereavement take place?
My lord, bereavement will take place, my lord, within a week, my
No, when did it take
Will
place? Bereavement take place.
for
When did the bereavement take place?
one week ago. It takes place, but he is outside Kolkata, he is not in Kolkata, that's the problem.
Okay.
My lord,
1/9/2025
my lord.
Grateful, Your Lordship.
at 2 p.m.
2 p.m., Your Lordship.
Milord 24, I appear for the plaintiff, Milord 1 and 2A to 2C, Milord.
Your call. What is the stage of the suit? 24?
Milord, suit is ready for Milord final degree.
Preliminary decree passed.
Passed.
Appeal preferred by
Review application,
review, my lord, review also dismissed.
Now the suit is ready for passing.
Yes,
final-
commissioner report is there. Milord, everything is Milord copy. Let be after Milord 21st, Milord. Let the date be fixed for Milord.
For submitting on the commissioner's report.
No, already commissioner report was there. Every
application is disposed of by directing.
rejected, not disposed of.
By directing to the largest court for taking the necessary correction of the defects. The technical ratio is not correct. That's why we are not not getting certified copies, and other issues is not resolved. Other issues.
The decree, the amended decree is not drawn up.
No. What happened, Milord? They preferred on the ground, Milord. That ground was not taken when appeal was heard. Appeal was, Milord, dismissed and preliminary degree was affirmed, Milord.
Yes.
Against that order, I have given the copy of
Where?
Yes, Milord.
The copy.
That was mentioned in the order.
It is-
Milord, I have given.
Review order and copy ta din.
This order was
Kindly go through.
Okay. This is 18 July 2025.
That is the Milord review rejected, Milord. There.
Madam, for the defendant number 2, I'm extremely sorry for joining virtually, madam. The preliminary decree was affirmed by the division bench and a review therefrom has been dismissed, my lord. And I'm under instructions that my client has approached the learned advocate in the Honorable Supreme Court for filing a special leave petition. I could take instructions whether it has been filed or not. It may have been filed or will be filed very shortly, my lord. And my lord, I was humbly praying if 1 week be given, my lord, so that
Yeah, I'm
the
at
Supreme Court can.
you take if the matter is before the Supreme Court, you take necessary
And
instructions.
serve notice. Otherwise, Milord, in this way, they are killing the time.
And there is, my lord,
Every
unless there is a specific stay,
stay.
lordship can always proceed with the suit.
Yes, record and order.
This is a suit of 2002.
Learned advocates for the parties are present. It is submitted by the learned advocate that although the preliminary decree has been passed and commissioner has submitted the report,
And that was affirmed by the appeal court.
but the final decree is yet to be passed. Learned advocates are requested to come ready on the next day to assist the court. Let this matter.
On 27th, Milord, Lordship kindly.
Let this matter appear on 27
August
8
8.
2025 at
Time will also kindly 2 p.m.
At 2 p.m.
Yes, I'm grateful.
In the meantime, take necessary instructions whether any SLP has been admitted or not.
Milord, they have to serve or show the before this court. Milord, not yet filed.
Okay. In the meantime,
They are probably not even on KVA.
Oh, we are the plenty, Milord. We are suffering from 2002.
If they are not on KVA, they are not entitled to service.
Have their rights.
They are minimum share, Milord.
Whatever it is.
Anyway, it has to be, it is of 2002.
Yes.
It has to be expedited.
Yes.
At 2 p.m.
এই তো বলতে দিয়ে দাও দিয়েছে না কালকে আবার
Lordship, I am for the plaintiff in this matter.
Defendant, my lord.
This is the defendant's application.
My lord, this is my application under your section 340 for initiating a proceeding.
So affidavits are complete.
Affidavits are complete, Your Lordship.
Well, what I was teaching with your lordship is that, my lord, we have specifically pleaded that if my lord take the application at page 43, my lord, there is a affidavit which I have, which is my allegation is that they have forged my signature and they have signed this affidavit and they have forged my signature and by using this affidavit, they have filed this suit.
Page 43.
43, my lord, the last page of the application.
Yes.
This application, my lord, see, this is they are claiming that this is a loan of 1984, while this affidavit is being signed on 2002. There is no witness in the affidavit, nothing. This whole affidavit, which is being relied upon by the plaintiff, is a sham affidavit, my lord. And my lord, we have specifically stated that the defendant used to be a director of some of plaintiff's company, and there were some signed picture, so my lord, signed papers with them. This is my allegation, and in their opposition, my lord, they have partially, I would say this, I would use this word very politely, they have partially admitted the fact that they had my signed papers with them in their opposition, my lord.
The suit was filed in 2010.
2010, Lordship.
In the meantime, my lord, I have
You filed your written statement?
And I have filed my written statement, my lord. And in the meantime, my lord, I have filed a application under section 25 before the Supreme Court, my lord, which was rejected. Thereafter, the Supreme Court granted me liberty to file my written statement. It was filed in April 2024. And what I was beseeching, subject to consent of my respondent, that let this application be pending, my lord. Let us expedite the suit proceeding. And my lord, while after trial, my lord decided is my allegation under section 3, what I trying to put in this application is right on. This is my humble.
Okay, so written statement is filed.
Yes, my lord. I have served upon.
Written
So
statement.
let
is-
the discovery and
My
inspection
lord,
be complete.
let the discovery inspection and let us come back with the issues.
Lordship, but in my humble
Discovery
submission,
and
this application cannot be kept pending. There is no allegation, Your Lordship. No allegation of forgery, Your Lordship.
Okay, record and order.
Kindly hear out.
Learned advocates for the parties are present. This is an application under section 340 of the Code of Civil Procedure.
Criminal code.
Criminal procedure.
Of the Criminal Procedure Code filed by the defendant. Affidavits are complete. As the written statement is already filed by the defendant, it would be reasonable to fix the suit for trial upon framing of issues and on completion of the discovery and inspection of the relevant documents. So upon considering the suit at the time of trial, this application may be taken up for consideration. Let the matter appear on 1/9/2025 for framing of issues.
Lordship.
Discovery and inspection must be completed in the meantime.
Lordship.
নেক্সট
Grateful.
যেটা একটা বাকি আছে বোধহয়। না না 4 PM এর আগে আরেকটা আছে তো 28 নম্বর। 28 হয়ে গেছে, তাহলে আমি 4টের সময় বসছি।
মে সাবমিট দেখো কেটেও দিল আমার ভিউ অডিওটাও নেই। चलो वो देख लाए क्या ब्लू, जरूरत तो नहीं पड़ा। जो हम बंद करते हैं वाला, लो देखो। उसका तो ले लिए ना यहाँ पे। चलो भगवान, फिर भी छुपा दी, भगवान को प्रणाम करो। तो फिर से करो। मेरा कौन सा? तो ठीक है, आइए हम लाए हैं, ये भी देखो। उसको तो 1 मिनट दूर दिखा रहा था, इतने मिनट से कर दिया आके कर दी जो उधर की आ गया तो मोड़ पे गया, लेकिन इससे ड्रॉप है करने दो। हम क्या पकड़े चेन बन के लिए बड़ा बिगड़ हम निकाल ऐसे बड़ा भी होते हैं ना, 8 दिखाता है। अपना दिमाग
Millard.
Yes. You are going to argue on the law point.
I will, Millard. There is not much law involved in this, Millard. I'll make it very short, Millard. Millard, these two proceedings, Millard, are probate proceedings of the same person.
Yes.
Same person executed two different wills in favor of two different Millard, beneficiaries regarding two different properties. So there is no legal bar. He can execute several wills in respect of several properties. There is no problem in that. When this was filed, Millard, thereafter, at that juncture, after filing, the court then taking the probate matters asked us to serve upon the legal heirs outside the jurisdiction of this court in Delhi. So we tried to supply. No one came. Then the situation came when it came to knowledge of the court. The court rather thought that we are not deliberately supplying. So court dismissed the applications for grant of probate. Then we went to appeal. Lordship was a part of the bench, honorable bench, which was taking the appeal matters arising out of these very probate proceedings with Justice Mukherjee, Honorable Justice Mukherjee. Now, that appeal court at that juncture said that no, the probate should not have been dismissed because directions for serving in Delhi or making paper publication in Delhi, Bombay, or the other principal towns were wrong, and set aside the order of dismissal and granted me to proceed.
I should not take up this matter.
No, I am not in conflict.
I have sat in the division bench.
Yes, Lord.
With a particular interim order. I have heard it in the division bench. So it's better I release this matter.
But there is no disconformity between that proceeding and here we are, wherever you are standing.
It is because with regard to a particular order, okay, that was challenged in the division before the appeal. And I was a part of the appeal bench.
There
Let
is
me
no
see the order, please.
The appeal court order.
Yes.
Because our lordship reads the order, lordship will realize there is no one to object, no one to contest.
Only
no one will ever. I don't have any problem doing this matter for your lordship because
anytime somebody can come for revocation of the probate.
But after these many years.
Okay, let me see this order first.
Appeal court order. Yes. It requires no one come for us to contest the appeals.
Yes, some order is there, observation is there.
But observation is regarding service, nothing else. Where to serve and how to serve, that's all. Nothing on merit, not a single line on merits. Because lordships are very clear, we are not deciding on merits. We were directed to advertise on newspapers, we have done it. That from 2010 to 2025, last 15 years, we are stuck here. No one has ever come to object this grant. Only because of the procedures where we are from this court to that court, then
anyway, but these attesting witnesses are to be examined.
Now, Millard, that is where Millard, on the last occasion also, that is where we stood. The issue was that Millard, since it is a non-contentious cause,
yes,
there is no one to contest. The procedure that is followed in this court for the last many years, Millard, since beginning till date, is that Millard, in respect of non-contentious cause, Millard, the probate is proved, or rather the will is proved, and probate is granted by that affidavit and not by tendering evidence from the witness box. That is the procedure of this court. I can for your lordship reference, where the other bench who are also taking the probate matters for different years. I have
is there any decision on the issue?
Yes, on that particular issue, yes. I am also carrying Justice Mukherjee's judgment reported in 2012 SCC Online Calcutta 502. So reported in this. if I be permitted to place this, my lord. The judgment of a division bench of our court, such and such, is foundation of this for this application to revoke the grant of probate. So that was a proceeding for revocation of grant of probate. Now that in this judgment, this issue was discussed in paragraph number 6.7 onwards. The grant of probate by this court is regulated by the Indian Succession Act 1925 and the original side rules of our High Court. The applicable provisions are those in chapter 35 of the rules. Section 23 of the Act inter alia provides that the district judge may, if he thinks proper, issue citations calling upon all persons claiming to have interest in the estate of the deceased. There is no special provision regarding the procedure for non-contentious cause grants. However, chapter 35 of our original side rules talks about non-contentious business. Rule 1 relates to this and is in the following terms. I am carrying the original side rules. I will show you, Lordship. I am reading it from here. Non-contentious business. Non-contentious business shall include the business of obtaining probate and letters of administration with or without the will annexed, and whether general, special, or limited. Where there is no contention as to the right thereto, including the passing of probates and letters of administration through the court in contentious cause, where the contest is terminated, and all ex parte businesses to be taken in the court in matter of testacy and intestacy, not being proceedings in any suit, and also the business of the lodging caveats against the grant of probate or letters of administration. The rule itself makes it clear that one could apply under that chapter when there is no contention with regard to the will. Rule 33 is most important. It says that where the procedure is not provided by the Act and the original side rules, the practice and procedure of the probate division of the High Court of Justice in England shall be followed. The rule makes it explicit that the practice of the English court to be followed should not be inconsistent with the Act and the rules. Since inception of this High Court, a practice has developed regarding grant of probate in cases where there is no contention. Adopting the nomenclature used in England, it has come to be known as a grant of common form. Before I proceed to make further comments, it is necessary to ascertain what is this grant in the common form as known in England. Let us see what Mortimer has to say on this in Probate Law and Practice 2, 2nd edition, quoted by the division bench in paragraph 15 of their said judgment in Ashok Kothari, Dipti Bhavisi, reported in AIR 2007, Calcutta 2001. Super. Then that paragraph is quoted. I am reading it for the sake of my understanding. A testament may be proved in two ways, either in common form or by form of law, which latter mode is called the solemn form, and sometimes proving part testative. A will is proved in common form where there is no contest about the will, but the executor, without citing the parties interested and in the absence presents it at the registry, and upon formal proof of its validity obtains the probate and seal of the court thereto. A will is proved in the solemn form when it is propounded in an action to which the persons interested as the widow and next of kin are parties, and after the proof examined and fully heated receives the sentence and decree of the court pronouncing for its validity. The difference in effect between these two forms of probate is that the executor of a will proved in common form may at any time thereafter be called upon by those whose interests are adversely affected to prove the will in solemn form, and if he then shall fail to establish its validity, the probate so granted is revoked. But if the will is proved in solemn form, no person who has been a party or privy to the proceedings can afterwards, by any fresh citation, put the executor again to prove the will. The Supreme Court of Judicature, Consolidation Act 1925, Section 175, subsection 1 of that country, defines common form probate business in a similar way as non-contentious business is defined in Chapter 35 of our original side rules. The definition in Section 175, subsection 1 of the English Act is in the following terms. Common form probate business means the business of obtaining probate and administration where there is no contention as to the right thereto, including the passing of probates and administration through the High Court in contentious cause when the contest has been terminated, and all business of a non-contentious nature in matters of testacy and intestacy not being proceeding in any action, and also the business of lodging caveats against the grant of probate or administration.
That means it is you want the will to be proved in the common form.
Common form. Because
Not in
there is no one is coming despite service. Had it been Milord solemn form, if I had proved the will with the presence of them, then the further contest would not have come. But because common form, obviously the right would be reserved. They can come for by revocation, by seeking that revocation of the grant. But Milord, so far as that common form is Milord, concerned, the procedure is that Milord, the procedure is that Milord, it Milord, is not required to Milord, lead evidence from the witness box. Because that lordship would found in subsequent paragraphs of this very judgment.
No, thereafter, pursuant to the order passed by the division bench,
Yes, Milord.
you have proceeded.
I have proceeded. I have proceeded. There is a report from the department that there is no caveat. No one, despite the news of publication, no one has lodged caveat. No one has come forward to contest. In paragraph 16, Milord, of this judgment that I have handed over, Lordship kindly read. If Lordship permits me to read, Milord, it once. Milord, 16 says that our original side practice has substantially adopted the above procedure. Additionally, the requirements of section 281 of the Indian Succession Act, which your Lordship was referring, have to be fulfilled. This section provides that this application for grant of probate has to be verified by at least one of the witnesses to the effect that he was present and saw the testator affix his signature or mark to the will. This requirement is not there in the common form practice in England. In that country, an attesting witness has only to make such a declaration if the attestation part of the will is absent or is insufficient. In our country, in all cases, this declaration is necessary. Moreover, probate is treated to be non-contentious in our High Court inter alia when consent affidavits are filed by the heirs of the deceased who would have inherited the estate if he had died intestate. A new practice has now been introduced that an undertaking the court has to be filed by the applicant for grant of probate that there are no other persons interested under section and such. Furthermore, the uncontested probates in our High Court are signed by the judge. It is on this basis that this court grants probate in common form. In fact, our division bench in such and such has noted that the English common form probate is not wholly followed by our High Court. I would like to say that the probate granted by this court in a non-contentious cause is a modified version of the English practice of granting probate in common form.
Now the question is, here there are two wills.
Yeah, here are many wills. Lordship will take one by one.
So it is not mandatory, but there is no bar. Court can insist on proving it the solemn form. That discretion is vested with the court.
But that discretion is definitely,
Yes.
no one can curtail the discretion of the Honorable High Court. That's there.
So
but I'm saying
there are two wills.
There are Milord total 5 wills. 6 wills of the same person regarding 6 different properties in favor of 6 different beneficiaries. We are here today, only 2 wills are appearing. Yesterday, 4 others were there in the list. Those are made not this week. So next week, those are coming. Lordship will take them one by after. First one, if Lordship is satisfied regarding service and regarding there, no one is coming for 15 years. Lordship can see 2010, I filed it in 2025. No one has ever come or not appeared to contest this grant. After 15 years, is somebody else ever interested in these properties?
Yes, whether any report is submitted.
Yes,
or
the
not,
report has come 16th of July 2025. I have taken this is what we have taken out from the department. At our request, this is issued.
So this order is passed only with regard to how many matters? All 6 matters?
No, yes, the composite order in all 6 matters, but we have made publications, and the same publications will, because same person and same legal heirs, if any.
No, this will, in this will, how many properties are there? 26?
21.
One property means only one immovable
One flat, 6 flats. I give it better. 6 flats in the same building. Every floor had 2 flats. The party owner by will Milord has distributed them among the beneficiaries. That is the thing. That is why 6 different wills. So Milord, if his legal heirs were at all interested for 15 years, they could Milord at least come once to say that we are interested in these flats. But it's Milord obvious that they have also lost interest if they at all have any. And Milord, no one has ever expressed any objection.
No, so 6 wills, 6 flats.
Yes, so when Lordship is taking up the first matter in the list, that only concerns one property. That is one flat.
So propounders are different.
Same propounder. 6 flats, 6
Beneficiaries?
Different. Different beneficiaries, different flats, different wills. There is no overlapping. It's not that not different same flats are being distributed 6 times.
Yes, record an order. Learned advocate for the petitioner is present. Learned advocate furnishes a report of the registrar wherein it is stated that general citation was published once in English Daily Statesman and once in Bengali Daily Dainik Statesman on 2/6/2025. And no caveat has been filed in the probate petition after publication of the general citation. And no order has been passed by this court regarding issuance of special citation upon legal heirs of the deceased. Learned advocate furnishes a copy of the order dated 5th March 2024, where an appeal was preferred and the appeal court in which I was a member was pleased to set aside the order of dismissal of this application for grant of probate. So it's not clear actually, you see, whether it was dismissed on what grounds.
But it was in the our lordship that the dismiss was on the ground of non-service, non-publication in the newspaper. That was the ground for dismissal, and that was set aside by the division bench, followed by further direction for publication in the newspapers, and thereafter because we showed that
as the said order was against the dismissal of the application of grant of probate for non-compliance of
publication
in the newspaper.
Yes, that was, we did not do it. That is why
newspaper, and it was not dismissed on merits. Learned advocate submits that this bench can take up the matter, as the Honorable Division Bench did not hear the matter on merits. Thus, this matter is taken up for consideration. Now, whether the matter, whether the probate will be proved in the solemn form or in the common form, that issue is to be decided on the next date fixed. Learned advocate has argued on the points of law in this matter. Let this matter appear on 13/8/2025 for orders.
13/8 for orders, grateful. But at around this time, 4 o'clock.
At 4 p.m. Item 27 also.
And the other 4 matter, 4 same between the I told
No,
you.
you see, if this has to be proved in the solemn form, the others will have to be proved in the solemn form.
Same form, yes.
And if this is to be proved in the common
So
form,
same fate. Not all these matters will have the same fate.
yes.
So in that case, lordship is, if lordship passes the order on that day,
yes, whatever order I pass,
will be applicable in all. So all these matters should appear together on 13th.
So
I'll supply the numbers, Milord.
The other numbers.
The other PLA numbers that are there.
Supply, it will appear on the same date.
Yes, 13th, Milord, they will
and if it is to be, you see, decided, proved in the solemn form, then it has to be done. But whatever it is, I shall fix it on a particular date at 4 p.m. all the matters.
13th August, Lordship has already indicated.
No, if it is to be proved in the solemn form, then you have to bring the attesting witnesses.
So that Lordship would indicate in this order or on that day's order.
No, 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 on that day's order. Today I have reserved it for orders.
Very well, Lord. So order, I will anyway that day the witness, if at all required, would not come with that because we would not know whether it is required or not. Lordship would indicate on that.
You have to summon them, whatever it is. Anyway, I shall decide on that date, but whatever it is,
Yes, they have
whether
to
in
follow
the
the
solemn
course.
form or in the common form, all the matters will be fixed on a particular date.
I only showed this, Lord, because Lordship can see for 15, 25, 15 years, no one has ever come and to object. In a non-contentious cause, Lord, the process I have shown what we
Had
follow.
it been one matter, I could have considered. So many properties are involved. No.
The same person, same testator. So legal as also all same. It's not that third parties will suddenly come and cannot come because I am in possession from the date of.
But there is a question, you see, this is not a gift. The will, a person can bequeath make many wills.
Yes.
But the last will come into.
Absolutely, that person in whose favor last will is allegedly or could be there for 15
Anyway,
years, that person would have come by now.
13-8.
Grateful, Lord. I'm only shown the practice of this court. That's that.
না দুটো আলাদা আলাদা করে দেবে yes
I know now it's not the time for mention. My lord, it was item number 19 today. I was assisting Mr. Ghosh where my lord was pleased to appoint a special officer, my lord, to visit. Now, my only thing, my lord, perhaps in the order it has not gone down that we have handed over the check of.
I'm not recording because you see it is not absolutely depositing check in court.
No, but we
It is
handed it over, my
no
lord.
it is partly there and partly here. That is why I'm not recording. Had it been exclusively here or exclusively in court, I could have recorded because one check you are giving to him, the other check you have to go deposit before the legal service committee.
That's, my lord, we record in that order, my lord, that 40,000 I have handed over and 10,000 I am directed to deposit. There is already a time frame. In fact, my learned advocate has already gone, will come with the proof on the next day. But 40,000 rupees check that we had handed over, he's accepted it without prejudice, but it's not recorded.
So that is item number 19.
19.
May I take your lordship's leave?
19 to 19 টা 19 কি অর্ডার নিয়েছিলেন না 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 19 একটা অর্ডার হয়েছে তো
Yes, yes. Annapurna Commerce.
19 এর অর্ডার যেটা আছে না 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 ওটা যে আছে একটা লাইন আপনি ঢুকিয়ে দিন আমি তারপর ওটাকে দেখে কারেকশন করে তারপর আবার রিটাইপ ওখানে একটা লিখে দিন লেট দি অ্যামাউন্ট অফ কস্ট পেড in terms of the order dated 2/8/2025 and handed over to the learned advocate for the defendant is without prejudice to the right of the defendant. The cost to be paid by the High Court Legal Service Committee may be deposited to the High Court Legal Service Committee, be paid in the office of the said High Court Legal Service Committee.
Extremely grateful.